Yes.
My lord, I'm appearing for the respondent, my lord, in item 1.
The heading hearing. Oh, no, we are on the mentioning still. Please give us.
Really sorry.
Because Mr. Chakraborty said here.
No, my lord. We used to appear, but we used to appear for the concerned department, my lord. So copy has not been received.
Where?
Let a copy be served upon Mr. Rakesh Kumar, and after that, my lord can.
Yes. A learned counsel for the petitioner seeks accommodation. Let the matter appear and the same on both of
My
us.
lord has kept it on Monday.
Monday.
My lord.
Are we okay?
Yes, my lord. My lord, item number 2, my lord, I am appearing, my lord, for the petitioner.
Yes.
My lord, may give me one moment. My lord, may kindly grant me a moment. Here, my lord, the question is, if my lord, I would request my lords to see a few documents.
The affidavits complete.
This is for arguments. This is a WPCT, my lord. They have not filed any affidavit in opposition. If they want to file, then in that case, my lord.
The affidavit was granted. It's not required.
No, I will place my case. Mr. Singh may kindly permit me, my lord. My lord, this is a case, my lord, where, my lord, the respondent, my lord, there is a series of documents, my lord, received from various institutes of eminence, saying that, my lord, the certificate, my lord, which was shown or which was produced by the respondent at the time of seeking employment is not valid. And because of that, my lord, being a doctor, my lord, his services cannot be continued, my lord. I'll just show each of those documents. My lord will first see a letter dated April 2025, which is at page 157, my lord, of the WPCT. My lord has page 157, annexure R5.
This is
Or
our.
P3. P3.
There are two numbers actually.
It says P3 on top and R5 below. It is 157 and 135. Or we can correct the numbers and my lord can then keep it on Monday, my lord. That also we can do, my lord.
1 and 157, yes.
Yes, my lord. Now kindly see, my lord, this is a letter dated April 2015, issued by the State Medical Faculty of West Bengal. Now kindly see, my lord, the contents of this. This has reference to letter number such and such dated 24th March 2015 by the Medical Superintendent Dr. RP Hospital Joint Director Health, North and Middle Andaman, Mayabandar, requesting verification of authenticity of Diploma in Dental Technique certificate issued by Institute of Medical and Technological Research 3 Bow Street, Calcutta. Institute of Medical and Technical Research 3 Bow Street, Calcutta is not an affiliated recognized institute by the State Medical Faculty of West Bengal, nor have the diploma certificate, mark sheets, etc., photocopies of which have been sent for verification been issued by the faculty. Now kindly see after this, the next letter, my lord, is 1st April 2019, which my lord will find at page 160 and 138. The two page numbers are 160 and 160 is on top and then 138. 1st April 2019. This is a letter, my lord. Issued by the West Bengal Dental Council. Now kindly see, my lord. I would like to inform you that the Institute of Medical and Technical Research, 3 Bowbazar Street, Kolkata 12 is not recognized under Dental Council of India, New Delhi as per Dentists Act. You are also informed that following institutes in West Bengal are recognized, then the 2 institutes which are recognized are mentioned. After this, my lord may kindly have the document at page 161.
Yes.
161, my lord will see the Office of the Deputy Director Health, Andaman and Nicobar Administration, Directorate of Health Services. This is dated 24 June 2019. Kindly refer to your office order number 4371 dated 31st September 2018. I am enclosing the final report of technical committee constituted to verify the qualification certificate of Shri Samir Iqbal Bajaj, dental technician, Dr. RP Hospital, Mayabandar, obtained from a recognized university or not. Now, my lord will see the next page. So this report, my lord, essentially, in the report, my lord, it was similarly held that it was not valid. Now, kindly see on the next page, page 162. This is a document dated 10 July 2019, whereas this is order number 2936. Whereas a disciplinary proceeding against Shri Samir Iqbal Bajaj is contemplated. Now, therefore, Director of Health Services, an exercise of powers conferred under Sub-Rule 1 of Rule 10 of Central Civil Services Classification, Control and Appeal Rule 1965, hereby place the said Shri Samir Iqbal Bajaj under suspension. Now, my lord will see after this. So, this is the factual situation. Now, in this light, if my lord sees the impugned order, which begins at page 15, my lord, annexure P1. If I may be permitted, my lord, I'll just quickly go through the impugned order because the impugned order contains the contentions of both parties, my lord.
Yes.
My lord will see page 16. The applicant has approached this tribunal under section 19 of Administrative Tribunals Act, praying for the following relief. A, an order setting aside order number 2936, which is what I had just shown. Memorandum number such and such, an order dated 4th March 2021 being issued by authority not competent to exercise statutory powers attached to the post of Director Health Services. B, an order be passed setting aside 1st September 2021 passed by Appellate Authority Secretary Health upholding the decision dated 4th March 2021 made by DHS not competent to exercise statutory powers attached to the post of Director Health Services. Then an order be passed directing the respondent authority to treat the applicant in similar manner as done in case of other similar cases by granting leave to acquire diploma certificate from recognized institute college. As per the applicant, Dr. SP Burma, who had initiated proceedings against the applicant by issuance of charge sheet, was assigned the additional charge of Director of Health Services, ANN Administration, with a order dated 19 January 2018. Therefore, the charge he was holding was akin to current duty charge. Further, Dr. Omkar Singh, being Chief Medical Officer, was holding the current duty charge as Director of Health Services. Learned counsel for the applicant has further drawn our attention to charge sheet, wherefrom it would be evident that under the list of witnesses by which articles of charge were framed against the applicant, Dr. Omkar Singh, CMO, was listed as witness number 2, who ultimately passed the final order by imposing punishment upon the applicant with a order dated 4th March 2021. Therefore, person who himself is a witness in the charge sheet cannot act as disciplinary authority. Learned counsel for the applicant further submits that the charge sheet and the final order passed by both Dr. SP Burma as well as Dr. Omkar Singh holding current duty charge is void ab initio as held by the full bench in Ajaib Singh versus State of Punjab. Learned counsel for applicant has specifically taken the plea that Dr. Burma and Dr. Singh were not competent to issue charge sheet or impose punishment being current charge holder. However, in reply, respondent have only dealt with the case of SP Burma, stating that he was holding post on officiating basis. However, nothing has been denied or mentioned. with regard to Dr. Omkar Singh. Subsequently, the applicant has taken all points before appellate authority. However, from perusal of appellate authority's order, it would be evident that without dealing with the issue of law involved in the case, appellate authority has affirmed the suspension order as well as charge sheet issued by disciplinary authority. Dr. Omkar Singh being aggrieved, applicant has filed the instant OA. Then, my lord, during the course of hearing, learned counsel for applicant has relied upon judgment in P. Hussain, wherein specific issue of holding additional charge with regard to Dr. S.P. Burma is dealt with. The issue whether S.P. Burma holding additional charge as on date of initiation of disciplinary proceeding as the applicant was competent to take aforesaid steps or was competent to impose penalty has already been dealt with by the Honorable High Court, and applicant being similarly circumstances entitled to get such benefit of such judgment. The respondent have filed their reply wherein it is submitted that such and such are denied. It is submitted that applicant is Group C staffer for which Director of Health Services competent authority and as per requirement framed for the post of dental technician. Further, as per Rule 8.3, President of India has delegated powers to administrator for appointment of Central Civil Service such and such. Dr. S.P. Burma, being a senior administrative grade officer from CHS cadre working under administration, was assigned additional charge without any extra remuneration, etc. Now, kindly see the findings. Heard counsel, heard the paragraph 5 at page 19. Heard the parties peruse material on record. In the instant case, 3 important law points have been referred by the learned counsel for the applicant, which is as follows. Whether Dr. S.P. Burma holding additional charge is competent to issue charge sheet or suspension upon the applicant or not. 2. Whether Dr. Omkar Singh holding the current duty charge of DHS can act as a disciplinary authority. Further, Dr. Omkar Singh being witness number 2 in charge sheet can act as disciplinary authority in the instant case. Then my lord will see that the finding, my lord, is recorded relying upon this decision in P. Hussain. And my lord, the conclusion is at page 20. From the above, it is clear that status of Dr. S.P. Burma holding additional charge of DHS without any extra remuneration did not have the competence or power to institute disciplinary proceedings against the applicant. Then my lord will see similar findings have been recorded regarding Omkar Singh, and a decision of the CAT is referred in para 5.4. Then para 5.5, my lord, it is recorded that it is further noted that even in reply, respondents have not even dealt with or denied contention of the applicant, which established the fact that Dr. Omkar Singh acted as disciplinary authority being current charge holder. Therefore, in a considered opinion, Omkar Singh has no authority to act as disciplinary authority and impose punishment. It is also settled principle of law that a person cannot be judge in his own case, and in the instant case, admittedly, Omkar Singh being witness in the list of witnesses in charge sheet himself has acted as disciplinary authority. So, my lord, on these grounds, my lord, the orders have all been set aside. Now, my lord, my limited, my lord, prayer before this honorable court is, my lord, there is a direction to reinstate the applicant to the post of dental technician from the date he was removed from service with all consequential benefits. Now, my only submission, my lord, is that the CAT has not gone into the merits of the matter. So, my lord, it has set aside the orders only on the ground of natural justice and on the principle that, my lord, the person who issued the disciplinary, the disciplinary authority was not competent. I am only humbly submitting, my lord, that that my lords may not, if my lord, as I would expect, my lord may not disagree with the findings of the CAT on those issues. But my lord may observe that, my lord, there are no findings of the merits of the matter. And if under law we are permitted to take steps in accordance with law, my lord, this order will not come in the way, my lord. That is the limited submission, because, my lord, he is a dentist.
But these authorities were under the law entitled to take these steps.
No.
These persons.
I am only my lord, what I'm yes.
Therefore, that now, merits need not have been gone into.
Yes, I am not saying that that the order is wrong because of setting aside on those grounds. I am not saying that. What I am simply submitting is, my lord, that this order will not come in the way of taking steps in accordance with law. Tomorrow, a duly constituted disciplinary authority should not be precluded from taking steps because these orders have been set aside. So, my lord, this will have a consequence, my lord, for administrative decision making. And, my lord, the thing is, my lord, he is a dentist, my lord, who's operating without a valid certificate, my lord. It's a very serious matter, and difficulties because, my lord, tomorrow, if a duly constituted authority also cannot take steps, because this will be binding between parties, my lords. Of course, my lord, as the court may say that, my lord, that the order is in the facts of that case. But for an administrative authority, my lord, the finding of the CAT and the High Court is binding, my lord. So it's very difficult to take steps even
You-
otherwise. Only this much of clarification I am seeking, my lord.
Reinstated.
You have complied with this order for the present. So he says that this order will not preclude the authority to.
But since it
No,
No,
this-
we will be bound of, it goes without saying, my lord, if this order is upheld, my lord, in any case, we are bound by the order. So we will, the legal consequences will follow, my lord. They will have, in case it is not complied with, my lord, they'll always have their recourse, my lord. There is no doubt about that. I am not saying,
issue, right?
my lord.
It is could not have initiated the proceeding or imposed punishment. There is not much to argue on that issue.
No, my lord, they have not argued in CAT also, my lord. I cannot argue anything new, my lord.
Asked you need to comply with the order, right? You are right that it will not preclude the authority from forming proper and taking necessary steps.
Yes, my lord. Yes, my lord. That much, my lord, if may.
Yes.
I was already the second day, 2006. And I have been very,
I can't hear Mr. Singh. If he can just switch on the mic.
There is no complaint against me that at the time of I committed any fraud. I have submitted my certificates. I have selected, I was
Sir,
given a
we
point.
are not considering the merits at all.
Yes.
Because the authority who has initiated the proceeding could not have initiated it, right?
That's
So
what the,
if that issue,
Yes.
so since an order is passed, there is not much to argue on this
Yes.
issue.
I-
So this order will not be, this order will be affirmed by us only with a rider that the authority will be at liberty. This order will not preclude the authority from initiating proceedings in accordance with law.
in that case, I would like to place the judgment. Now in Haryana High Court, we will not out that the judgment of Ms. Mudgal versus S.C. Hegelkar, where the appointment was made by the default. Then continued for 10 years, 15 years. No action was taken against him.
That's an issue.
But that has not been decided by the CAT. This argument will be raised before the original authority, not before the High Court when considering a challenge against.
At that point at all.
The question of law only. Question of law only.
There's nothing, not much to argue
Yes,
on
sir.
this issue because these authorities did not have the, I mean, they were not entitled to initiate the proceeding. So if the initiation is wrong,
No.
it's with law, then the proceeding goes.
Because another question is to say whether if we need proceedings can be initiated, particularly when the applicant has not committed any fraud, we see for misrepresentation at the time
It's,
at the time of that is on record.
if at all in future, proper proceeding is initiated by a person entitled to who has the authority, it can be dealt with.
That is up to them to do it.
Absolutely. That
Why
is
did they want so in the High Court in this direction?
That is, I think they have.
the final.
Well, they can start if they feel like, but in why they want a from the only on the from the honorable High Court?
Because this.
Because then they will say, honorable High Court has directed, that's why we are
No,
conducting.
no, that cannot, that is, but
The why they can free to do it. Good person.
This may let us res judicata.
It will not. It will not. Only the question of law.
Again, a matter of argument, whether
Yes,
it will
ma'am.
or will not. So
Yes.
let there be a rider and they'll be clear. That's all.
But it's
This
not
is
be,
direction.
but it's not be treated as the mandate of the honorable High Court. No.
not a.
That's up to you.
His lordship.
The appeal is directed against an order. Judgment in order dated 18th of February 2025 by Indiraj, the Central Administrative Tribunal, Kolkata bench. Kolkata Circuit Bench at Port Blair. Next paragraph by the impugn order the learned tribunal quashed and set aside the orders dated July 10, 2019 and July 17, 2019, as well as uh, m- March 4, 2021. So the learned tribunal also directed the respondent to reinstate the applicants to the course of dental technique from the date he was removed from the service with all consequential benefits immediately. Next paragraph. It has been submitted on behalf of learned advocate for the appellant. Submitted on behalf of learned advocate for the appellant that the tribunal not to go into the merits of the uh, appointment of the private respondent. So it only decided on the issue that the authority which were acting as the disciplinary authorities. And what was the second one? So, Omkar Singh,
Omkar Singh.
He was a witness. He was also, one of them also acted as witness. And
He was a witness in the charge sheet as well as he was a
disciplinary being a charge sheeted witness. So the honorable tribunal, the tribunal so the initiation was also not by an authorized. The elect. That he has not to argue in this matter.
my lord may not record that, my lord, then I will be in difficulty. My lord may only dispose it of, my lord, because they have not argued it before CAT, so I cannot argue anything more, but my lord may not record it as my submission.
Submitted that the such or past by the learned tribunal to stand in the way to initiate a proceeding against private respondent in accordance. That is okay.
Yes, my lord, my lord.
Next part. Appearing for the opposite party. That the respondent was appointed for it far back in the year 2006. So there no question whatsoever was raised regarding it's to be appointed in some. So the appointed back the appointment was that respondent. For have a case on April 6, 2006. So the person to the to such a good the opposite party applied recommended for the on May 2, 2006. By the 2015, director of Northern Middle and State Medical Facility of West Bengal to assess the genuineness of the that is dental technique. So the response in response to medical Facility of West Bengal wide it's related at 6/2015 stated that the Institute of Technical and Technological Research, 3 was not an affiliated slash recognized institute by the state medical faculty. For the diploma certificate and the private property such faculty. So the such and in order to further inquire the mathematical for the technical committee constitution on September 31, 2018. So the response dated April 1, 2019, the Register of West Bengal Digital Council informed the Institute of Medical and Technological Research over the state Kolkata was not recognized Institute of Medical Council of India. So based on such correspondence, the technical committee in its report dated June 2019 stated that the qualification certificate of the opposite party was not obtained by recognized university slash institute from the pursuant to the review of the technical committee. Was placed under suspension by dint of an order passed on July 10, 2019. But accordingly, the charge was July 17, 2019. the query was tested. Website is recording on this deeply continuing on query. The completion query, the disciplinary authority, that is the director of health
Dr. Omkar Singh, the editor, federal duty, that
on Omkar Singh, holding the charge of special duty, holding the current duty of director of health services. By order dated March 2021. An order for the removal service of the opposite party in terms of Rule 11 of Central Civil Services and the bracket is CCA. Rules of impose penalty. Term. In its the private option preferred field before the appellate authority. Such appeal from the appellate he observed that the charges were proved both in the committee also the authority. Subsequently, the appeal was dismissed. The by an order dated September 1, 2021. So the such order sailed the private opposite of the central administrative tribunal where the order was passed. The- the- Yes. Right. 5.5. That is the fund from election. 5.5.
It's.
By the input of the central administrative department, set up like under challenge. The order dated like 10 of 2019 like 2020, as well as for 2021. So basically the learned tribunal, while disposing of the
Original application.
original application, disposing of the original applications, held that the the Director of Health Services would not have exercised statutory powers under classification control and appeal rules to charge sheet an employee whom he could not have charged sheeted while holding his substantive medical superintendent in medical the of that the charge to against the private not issued in accordance by a competent person authorized to issue such charge sheet. Subject. It was also held in the order that the person who acted as a disciplinary authority in punishment upon the private opposite figured as a witness in the disciplinary proceeding. Stop here. He being a witness to the disciplinary proceeding was not authorized to act as a disciplinary authority and impose punishment. Next. Advocate for the parties and on consideration of the materials placed before us, we find no reason to interfere with the implement. So far, statement is concerned. Stop here. Since the learned tribunal, by the impugned order did not go into the merits of the issue, we are not inclined to on the merits of the case. Stop. We, however, observe that the the present appeal or the order in shall not be cannot preclude the authority from issuing from taking any steps against the private opposite party in accordance with law. According next paragraph.
Just one humble request, my lord, where my lords have recorded my submissions, just if it commends to your lordship, only while recording my submissions, my lord, to add one line, my lord, the charges against the respondent are serious and reinstatement will have huge financial implications. Just this line may be added while recording my submissions.
Okay.
It is his submission only.
Only submission, not.
Taking observation to that. It will only be his submission.
last accordingly, the WPCT 18 of 2025.
Most grateful.
I correct it.
Yes, only that reinstatement will have huge financial implications and the charges against him are serious. Only these two things.
Learned advocate for the appellant also submits that
No, we are affirming the order. That is only
reinstatement
list.
of the private property will have huge financial obligations upon the authority.
And my lord, the charges are against him are very serious.
And the charges framed against him were of very serious nature.
My lord, most grateful.
The first day at the time of
Most grateful.
On prayer of the petitioner, the matter is adjourned for the day. Next. Where? On prayer of the petitioner, the matter is adjourned for the day. Who's appearing for? Don't find him. Tell me, please come. This is for admit. Has not been served. Learned counsel for the petitioner seeks accommodation that the matter appear under the same heading on Tuesday, 5th August. Next. Sir, who's appearing? You're appearing.
This was for before.
Yes, but you need to serve the correspondence. Where is your affidavit? No, it was dismissed earlier. Is the affidavit of service on record? That needs to be served. That's what I'm asking for.
No.
10th June. No, it's the 9th June service. The order was passed on 10th June.
10 June.
You need to serve it. You've not served as. Yes. Please come back with the affidavit. Since service upon all correspondence is not complete, when can you come back Monday? Let the matter stand over till 4th August 2025. Whose order? Whose order is on the point? We cannot do with this. Oh, they are by the contempt against the sitting judge's order, right? So this court, this bench cannot deal with it. It has to go to the, this court cannot
It
deal
has
with
to.
this, madam, okay? This has to go before the judge who has passed the order. The order under contempt. So the judgment under contempt has been passed by an honorable division bench of this court. Paragraph in view of the above, comma, the matter is released from this list and be placed before the Honorable the Chief Justice, comma, High Court, Calcutta, for necessary directions. For appropriate directions.
I don't say that is your
Yes,
The statement of it, the judgment of in the proceeding under the prevention of corruption.
yes, sir, you're hearing for the state and you're for the responsibility. Yes, sir.
Yes. Junior engineer in Kira Parisha, that is Kadamgar. At a different sort of time, complaint engineering, or construction of some rural road by the cooperative society applied executed the work during the clearance of the bill. This junior engineer demanded rupees 12,000 from the society for clearing the work. That was right. That was demand. And accordingly, the being a member, that is the defector complaint, talk to the secretary and the president of that cooperative society. They not agree, that they are not willing to give. So they are waiting for clearance of the activity. Thereafter, they have clients made a complaint to the anti-corruption unit that they demanded, and he takes. For that, he has filed a written complaint, defector complaint on the basis of demonstration was done. That reached the spot with the anti-corruption unit along with the defector complaint, and that's what rate and that we have received that 8,000 as advance out of 12,000, and that was recovery was there, and was arrested, and completion of the investigation afterwards. Trial courts, the drama is witnesses, including the defector complaint, are independent witnesses. Yeah, 12, including the investigation officer. So, I cannot go beyond the report that himself with Namaskar. He not supported the case of the prosecution. I certainly submitted the case because I cannot go beyond the record. But my specific is why adducing the other independent witnesses, two independent witnesses who are government servant at that relevant point of time, they participated in the Peter proceeding regarding handing over the money by the defector complaint between the TLO, that is chief flying officer, demonstration, everything has been put. Thereafter, when the junior engineer was deciding to what on the case, that means all the police personnel It there, they stand in the position when the defector complainant has given the money, 8,000 rupees. Immediately the police officer entered into the room and found that it was something the money. That money was tainted, money was recovered, and the chemical examination was done at the time of the proceeding, after proceeding, everything has been proved. Question regarding accepted as by the court. Specific argument report that even a defect of complaint become hostile. But by way of pre-trap proceeding recover and under section 330, the statement of the accused before the trial court, no explanation that what type of amount and how it was paid in the pocket. That is the figure. It is the burden of the prosecution to pave the case beyond all reasonable doubt. It is settled principle. But even some burden here in this case shifted there. So the recovery proceeding regarding handing over that was proved. The recovery of money has been proved. The no explanation from the side of the respondent yes, that money belongs to not given money, it was not given by the defector government. So kindly come to the evidence of the individual. One first, PW, that is appearing in page number 2 of the paper.
PW2 is at page number 6.
It is one. Sorry.
Page number 2 is
Two
PW.
is the figure. Two is. Very lost.
Yes.
I have posted as personal looking secretary at HTC on 7 March 2013. I was posted at the same place in the same. On that day, the deputy secretary pastor asked to me to accompany Ravindran at PS Anti-Corruption. According to PS Anti-Corruption and make the university at about 11:30 AM and he told us to meet Inspector Daniel. We met Inspector Daniel and he told me that we have to go for trap at 12:30 AM. Thereafter, second paragraph, when there, second last paragraph, Lord say, one clear plan was made. At the House of Power, the 16 GC notes of rupees 500 was taken from complainant to us. The same GC notes were treated with phenolphthalein powder and envelope, and the same envelope was complainant. Proceeded toward the house that is quarter of artistic. The complainant, along with Anjan, came inside the quarter and Anjan was directed to give the signal after transaction. We were waiting outside. Next page. After transaction, then he completed quarter and thereafter we all along with police personnel were inside the house and on reaching the artistic was confronting the money and police team got hold of both of his hands. Artistic was to give his hand in a two separate glasses of water and on taking the water to pee. Thereafter the same collected into two separate bottles and both bottles were filled. The currency notes were also filled in an envelope. The artisan was bought at police station along with the sealed article. Artisan indicated Parantala purchase at the time. Is placing the book and that was found. Thereafter, the case was debarred by the prosecution. Next, page number 8. I was giving the feedback. First page is at about in respect of the recovery lordship. Then we I was written in the feedback proceeding held at and over 16 DC note of rupees 500 to the PLO. It is a final lordship. Because the notes were handed over the complainant. Because why I am emphasizing this part, complainant became host. Still not confirmed. Then thereafter deep my finger into water glass. By doing so, the water did not stay. Over the DC one decided making some kind of pattern for the body. The deer added some chemical on the water. The deer further instructed me my finger into glass of water mix. Will not turning powder when the color of the solution changing to tea. The deer started washed our hands with the fresh water. The deer handed over the tainted for keep and not keep the pocket of the complainant. All the classes are properly. We then proceeded to the quarter of complainant situated at Bharatala. Then This two quarter of JE at Calcutta. Thereafter, asking the complainant in front of the quarter of the JE. The complainant Anjan entered into the quarter of the JE and was standing outside of the quarter of the JE. And the other traffic member were there keeping some distance from me. The friend of the complainant, after some time, came out of the quarter and transmitted signal to me by wiping his face and got in the signal. I passed the traffic member. Thereafter, myself and entire staff team entered into the quarter of the JE. We found that the JE was counting the notes by using both of his hands. Inspector Daniel, for hold of both of hands of JE by catching the series. Inspector Daniel took out of the tainted note from the hand of the JE. One constable prepared a solution in a glass of water by adding one pin of the Mr. Daniel forced to dip the right hand of the accused into the solution when the color into the piece. Thereafter, by using the same method, the left hand of the JE was with phenolphthalein solution. When the color of the solution becomes pink, the hand washes or put the hand for into fresh bottle, which was sealed and labeled. The tainted GC were also tainted and sealed and labeled. Thereafter, the JE was arrested after observing local formalities and was brought to the authorities. The name of the JE was RK Singh. He was presently identified. I put my picture on all levels, acting on the technical level and on the Twitter post and identify the same. It is a very vital part, Lord. Regarding Twitter, handing over the DC currency note of denomination 500 rupees total amount to 8,000 was handed over to complainant with the instruction. We will go to the spot. After getting a signal, you have to hand over the. So this PW is the very vital independent. Just like this witness lordship, another witness that is PW lordship. Page number 11. Page number 11. Same, he has and PW to corroborate the entire evidence regarding Twitter, post-trap, recovery, everything, lordship. Then I am reading lordship. May I read lordship?
He also turned hostile.
Lordship done household, but some came. He has corroborated the position of PW2 regarding Twitter, some slightly recovery. It completely was not hostile. PW2 well stated before the trial court what was actually happened since Twitter up to recovery and arrest of that person.
Yes.
And then first PW6 is a TO. That playing officer. For exam, right? Just
PW6 is the person in whose precedent, according to prosecution, the pre-trial proceeding was conducted. Declared hostile and said, I was aware of the case, no pre-trial proceeding was conducted at my residence.
then PW7 is also independent of this. Kindly come to the page number 23 of the page. 7. PW7.
Yes.
Good Bahar. Yes. I may be reading also. Presently posted at traffic posted as constable. On 6 March 2013, I was posted at CS Anti-Corruption Court in the same company. On the same date, during time, I announced that Peter and PCR were called by Inspector Daniel and asked to attend the office on 7 March 2013 at about 9 AM to accompany him in a day. On the next day at about 9 AM, I attended the office accordingly at the temple. And I found two clerks and another from the secretariat who were also present beside us. We were briefed to accompany him to Contempt for a trial proceeding and get arrested. All of us to ready with the taxi and other articles required for the same. On the day at about 12:30 PM, we started from anti-corruption on a private vehicle. We arrived at Contempt at about 5 PM. When we met a person, namely Sardar, who was the complaint in that case. Another person, namely Anjan Kumar, also present, we said Baba Sardar. Page number 24. being requested by the inspector Daniel, take Prabhakar took us to the house of one Jyotirmay Kawal, who was a member of Jila Parishad. After arriving at the house of Jyotirmay Kawal, Inspector Daniel received from Mr. Kandar, and I was asked to fact the PS anti-corruption. I came to Padantala PS private vehicle and fact the PS anti-corruption. On my return, I found that the pre-plan proceeding was complete. Complainant informed us that the person concerned, namely Rajesh Kumar Singh, junior engineer, agreed to the bribe at his quarter at Karunda. The complainant being accompanied by Anjan Kumar with the quarter of accused and therefore inspector instructed Kuldeep Bendi to follow the complainant from some distance was standing on the main road near the second along with the traffic. Thereafter, complainant started being accompanied by Mr. Dipti entered into the quarter, being inspected by the inspector Daniel. Mr. Dipti gave us a signal by wiping his face with a handkerchief. As soon as the signal was received, all entered into the quarter and found that the accused was counting the bribe money by sitting on the chair in the fourth room of the quarter. Inspector Daniel got hold the hand of the accused and recovered the bribe money from him. The left hand wash and right hand wash of the accused was corrected by pouring his own hand into different glasses filled by sodium carbonate solution. And after dipping his hand, the color of the water turned pink. Thereafter, both the hand wash were collected in two separate bottles and sealed with the label and obtained the signature of the witnesses and myself. Thereafter, Inspector Daniel tailed the number of 16 currency notes of denomination of 500, that is the bribe money, and those were found correct. Thereafter, said currency notes were kept in a cover and label was affixed after obtaining a signature of the witnesses and myself. These are my signature on the label of the sealed cover containing the seized currency for signature to mark as match exhibit Roman 3 by 4. This is my signature on the label of the all the exhibits were shown to the witness and all the materials and other documents. So this 7 PW7 and PW2. PW2 was the independent witnesses. He deposed and is a witness from the administration. He has seen everything, Lordship. And kindly come to the document, the PTA procedure, how it was put, because the TLO was expired during that. He could not be caught. Regarding that document, how that document has been proved by these other witnesses, that can be taken into consideration, Lordship. I am coming to the PTA proceeding, Lordship, that is page number. Can we come to the page number 50? That is taking over and handing over of currency.
Yes.
Page number 54, before starting the data procedure, where the procedure for handing of the notes between the TRO team of anti-corruption and the complainant, that this money has to be given on the demand of the accused person. So this handing technique was kindly comes to signatures, last page number 56. Page number 56.
Yes.
Because I see all the signatures have been identified, the person who deposed before the trial court. First, they took the B. Daniel signature because it was expired, signature could not be exhibited. And you see the exhibit 2 by 2. This is independent, Kuldeep Benedict, number 2, this is number 3. All three signatures and on the signature of the component, that is the cover shut, the exhibit 2 by 1. So, quashing event, the time was expired. Document entirely not exhibited, but it has been proved by the prosecution before the trial that yes, the handling and taking memo was prepared on the spot by the TLO before this thing it is only and 57 lawsuit that is PTAC proceeding. After this handing over, PTAC proceeding was conducted. How to what, how to give the money. PTAC proceeding, lordship, see the page, last page number is 59. This document also very lordship, and it is proved by the independent witnesses. It's not required that you has prepared it, lordship, and the document has to be executed. Only the duty of the prosecution to prove that document by adducing the list of independent witnesses who are cited as 1 and 3. That is Koti Benedict Topu, Ravindran, Anjan Kumar Rao, and also two police officers, including one police constable also. So regarding handing over ATM, it is true. So kindly come to the recovery, that is page number 60, appearing page number 6.
Yes.
So I may be permitted to read this. This is very important and vital part. How the money reached to the pocket of this respondent, that is very vital. Today on 7th March 2013, 215 hours, the comprehensive Prabhashkar Uttaran Sri Anjan Kumar Uttara proceeded to arrange a court after that proceeding was over to meet the arranged with proper direction. One independent witness is Kuldeep Reddy took forward and observed the movement of the complainant and Sri Anjan Kumar when they meet the judge in the court. Member says that become their history. Guru Bahadur, PC, CR, S. Ravindran were directed to suitable position to maintain shadow vigil in around the premises of the quarter of G. At around 20 hours, we could be receive the pre-identified signal with handlers from the complainant friend Sri Anjan Kumar. He immediately passed the signal to me, inspector area, and subsequently the traffic members we noticed that the complainant when Anjan Kumar were there, we also noticed that they are holding the money and also counting the money with his both hands. If TLO spot the both hands of them by wrist, they disclose my active to the apprehended and also improve the tracking to him. The LHJ whom we started training on checking of the cash rupees 8,000 denomination of rupees 500 Indian currency note were recovered from the possession of LHJ. It was noticed that 16 numbers rupees 500 denomination of Indian currency of rupees 8,000 was serially numbered such as recovered from the possession of the apprehended J. Sri Rajesh Kumar Singh. Then he has started to get the serial number of the recovered currency with the serial number mentioned. In the taking over the and treat of proceeding and they were found tail which each other. All the trapped team members and independent witnesses were satisfied and confirmed the same. Thereafter, same PLO proceeded with the Pinopetharin case to the ensure whether the finger of the apprehended TD has cut the Pinopetharin from the near all the currency note recovered from position. Or these are glass of clear water or sodium carbonate was prepared in the presence of complainant. Independent witness and LHJ was directed to deep his right hand finger in the color sodium and water. When he did so, the color solution turned into a pink color. It means this right hand finger touched the entire money smeared with phenolphthalein powder. Similarly, another glass of clear water dissolved with a sodium carbonate was also prepared and the LHJ was directed to do his left hand in the colorless solution. When he did so, the colorless solution turned into a pink color, which means that his left hand finger have also touched the phenolphthalein powder smeared on the color. On this, it was established that he has accepted the right by hand and counted the steps before he put place in the some other place. All the solution were transferred separately in one each along the post and sealed with impression of Ashoka RH right hand wash and left hand wash to denote right hand wash and left hand wash of the LHD. All the drafting members have witnessed the changing color solution and confirmed the same. The signatures of the concerned witnesses were obtained on the label pasted on each bottle. The recovered tender money totaling rupees 8,500 position were put in the separate envelope, sealed with the impression of Ashoka stamp. The signature of all witnesses was obtained on the seal cover of recovered money. On the strength of recovered money, and exhibits collected to the process the final piece of had been made out. The LHD, as well as the artist arrested on the spot at 21 hours under the above section. All court formalized and brought at here for lockup custody. So Lord, it is a very vital thing. It is well proved without any bribe money, that the money which was tallied at the time of pre-trial proceeding, because pre-trial proceeding demonstration at the relevant point of time, that currency note which was handed over by the TO to the defector complaint, tallied when it was recovered from the
Can you please show us the complaint?
complaint. Page 50. Page 54. Page 54.
54?
The complaint dated 20th April 2016.
And the free trap proceeding, etc., was in 2013, 2013,
2000.
13.
No, dated, complaint dated is 7 March 2013. Complaint date is, can we go to the page number 54? Dated is 7 March
7
2013.
yes.
And
This is on the same day.
then declare for seven months. Because the complaint went quicker, then the complaint that was submitted by the PW7. Regarding other witnesses concerned, I started on the point that other 16 witnesses, some scissor witnesses regarding some document within the record lordship. I will not take much time in that part regarding related works. But a document has been received. That's relation to execution of construction work. That's only proof that related to that work. Money was demanded. Even a defective complaint and became hostile lordship. Regarding the recovery of money, because it is well proved by the prosecution before the trial court regarding handing over recap from the position of these accused persons, the money was recovered, it was carried when the money was given to the prosecutor by TLO, it was carried. It means it can be presumed by this court that this money was given by TLO to the defector complainant was from the position of the accused person. A question regarding demand and acceptance law. Demand and acceptance requirement criteria has to be fulfilled by the prosecution. It is a settled principle. But the courts, the trial court,
Yes.
Court, at the time passing the judgment lordship, did not touch and did not discuss about this fact because argued before the trial prosecution regarding demand and accepted. No observation has been made. Only plainly it is stated that de facto complainant have been hostile and the prosecution failed to establish that there was a demand from the side of the accused person. So benefit of doubt was given to the accused and he was acquitted from the case also. So my respectful humble submission, because the trial court did not appreciated the evidence of PW2, that was the independent witnesses and PW7 and the executed document, that is a handing over memo, future proceeding, and the most vital is the document. And regarding the statement, termination of the accused under section 313 CRPC, that also not which part, that was also not discussed. by the
Where is the statement?
30. I am coming to 30. Page number, start from the page number.
95.
Number 30. 32.
34.
30. So, starting 34, let's see, railway question start from 35. That is only that I do not know. I do not know. I do not know. And you see up to page number 30. 40. Up to page 42. Page number 40 is the vital loss.
Yes.
Question number 32. PW6 further stated that he can caught hold of your hand and took himself to remember to absolutely false. Just a minute, before that.
No, there's nothing much in the 330.
330. So my specific argument on that point regarding the recovery from the possession of the accused lordship. It is a burden of the prosecution to prove the case. But it also here this case, some burdens slightly shifted to the accused because opportunity was given to me to explain yourself. That is statement under section 330 CRPC.
How do you substantiate the demand?
Lordship, regarding demand, Lordship, because the de facto complainant become hostile. He did not support it. He specifically said regarding nothing has been said by demand. But demand and acceptance of both has to be proved by the prosecutor. Okay. Kindly see, demand regarding no evidence. I cannot go beyond the record because the de facto complainant become hostile. He is the best person who could have been said that yes, who has demanded the money. But kindly see, the recovery, there's acceptance related to the demand. How the currency notes came into the pocket of the respondent? It means there was a demand, even if the pocket of complainant became hostile. It is not a specific because evidence given by the de facto complainant. Yes, 8,000 rupees was demanded by the accused for clearing the bill. But if you see the recovery memo, if you was seized from the pocket of this accused person, you was counting the money, then the acceptance related to the demand, if there is no demand in relation to what type of works the money was recovered, no explanation in the deed. It could have been stated, yes, recovery was made, it was a false case, somebody has implicated me because there was no demand and this money was connected to other things.
He has stated that he has been falsely implicated.
Only false implication. Only false implication is stated. Answer the false implication, false implication. It is not a true. But when the prosecution has finished the recovery and see the money from his pocket, some slightly burden shifted to the accused person to say something that opportunity was given on CRPC. That he has not stated. That because it is well proved, he cannot deny. High Court has observed years, recovery memos made, currency notes were recovered from his possession. It was also his duty because Section 7 and 13 of the POC Act also. He has demanded money. Regarding recovery, it is true. And regarding other evidence, I will not take much time regarding that one. These are the vital argument on side of the prosecution lordship. This is my response.
That's all.
This order
Yes,
I am
that's-
liable to set aside.
He has denied the content, sir.
As far as even the the so-called staff this document, they said they have signed to dealing at the police station. My lord, can we come to? Page 10.
Yes.
Documents are just make that, when you post, when you put the presentation, yes, sir. But I can indicate the evidence of all the pictures. Businesses can, I mean, PW, one million to take nothing, not. Right? When he was brought to down, then he was economic, right? Bills have been processed, we have received key payments. So it is do something of phobia to do something, man. If I make a demand, in a capacity as a public service, the government service, either to do a favor or phobia to do something, man. If there is nothing to be done. This is the process, as paid and received. Then it demand doesn't survive, my lord. He says, my lord, here, at page 2 of the paper, third paragraph, and this indicates the relevant portions, my lord, because I don't take much time. Paragraph 3. Police called me on 7/20/30 and took my signature for some papers. My statement was not accepted by the police. So times the complaint, whatever he has signed, he says that he is later on. So kindly come over to page 3, my lord. Last cross examination by the prosecution and to take that time. I have stated up to my colleague medium, I do not know English language, the payment to the society to the equal that on the basis of the bill preparation J. Since number 2012, the society is funded work of and at that time, actually, work the JE of the Panchayat society was awarded work of construction of footpath from the house of so the work was completed from capital and the bill for the work was prepared to the check of was paid to the society. Not the fact that the complaint in which I identified was read over and explained. I put the signatures down, not the fact that the accused demanded right only for creating the not the fact that it is certainly complained by me that I belong to the or that 12,000 was recorded. Not a fact that as the accused was frequently demanding the fact and as such I contact the anti-corruption, not the fact that when the accused demanded bribe of 8,000 from me, I was a complaint. Then skip a line minor, like security deposit was released from 7 so nothing was pending. Even the security deposit, civil work, when I take to the work, 10% of the amount from the unlegal of the matter will be collected as a security deposit. To ensure that the execution is in accordance with the specification. But the party satisfied that the security deposit was also released. Nothing was pending, either the deposit was pending with the authority. The recovery also. People also prepared there. I about the other witness to be sickness provision, not the fact that thereafter I can belong to the educated witness. So figure to be one of the accused or the accused demanded something or then I handed over the case of accused in presence of educated witness or thereafter the have used along with witnesses of these which all can be gained from the company. From these, it's all not a fact, all not a. On the case, my lord. The last page, last three lines, I have received all sections respective to the I have those demands against the representative. I put my signature and clear those papers and I put my signature on the pasted labels or labels of the bottom. Like the signature was taken and the labels were not prepared and pasted later. That's an explanation. Well, very importantly, page number 6, PWP 2. So now witness the prosecution through him whom they want to possibly demonstrate the recovery. Now, when he was examined, basic he said, one retrap and was located at the house of Bawali. So Bawali was examined as a prosecution witness PW 5. PW 5 also does first time. He says that no proceeding was ever conducted in his residence. And his signatures were obtained by the police officials later at the police station. So, in 6, he said one kitty trap was made at the house of Bawali. Also, in this paragraph, the complainant along with Anjan were sent inside the quarter and Anjan was directed to give the signal after transaction we were getting outside. Now, this Anjan, so he is also a member of the society who was able to the quarter executed, completed payment and executed release. And after the prosecution, Anjan was one of the persons aware of all these allegations, and he was also, along with the complainant, according to the prosecution, when the complaint goes inside the authority, but when Anjan is brought to dock, he also does not support the case of the prosecution. He denies the demand, he denies the recovery, he denies going to the house of the accused, he denies the pendency of repayment, does not support or substantiate the case of the prosecution. Is the prosecution intending to prosecute the person or prosecute the person on the basis of two witnesses, the so-called witness who did not hear any of the alleged allegations by us, because we are to do everything. Let's say, when it to go in the cross-examination that page ballot. The interior of the quarter was not visible from the place where I was standing. It is the fact that I have not heard the conversation between the complainant and the accused, nor I have seen the conversation where I was standing outside the quarter. I think even these witnesses are not in the position to establish a substantiated proof because of the property.
Was not been proved that the legal for the legal change was found. And they were complained. I have not said that we have said. This have not.
PWC, the other witness, same as the cross-examination, they, he does not hear the demand, he is demand, he does not, he somewhere outside, he signs everything at the police station at page 48. He says that police never interrogated me. Proceeding was conducted at his residence. Nothing was handed over the inspections. He has no knowledge of the case. Absolutely not support the case of the prosecution. Page number 8 is PW6 Daniel Minor is the police personnel. I will not 6 and 7 are police personnel minor. And 8 is an official of the panchayat from whom this tender documents were handing over was done and the payment details were recovered from the office of the panchayat. And because to 10 my lord is Anjal Kumar Roberts, according to the case of the prosecution, he was the person who goes along with the accused for the house. And according to the prosecution, the became one but when called on dock, that's what the case of. But even if he goes, recovery is not proved by her. The company was not suit that the demand is approved. And as far as 313 is concerned, it is not mandatory upon the legal lengthy explanation. He can keep mum and also aware of it. If it is required, he can give, he can say yes, he can so, he can give the explanation, it is fine. But the answers what I given does not support the case of the authority.
That's all. Argument concluded, judgment reserved.
Perfect.
Yes, next.
Lord, in this matter, Mr. Kasarkar is appearing for on behalf of the applicants.
Respondent.
No, no, he's in out of station. Let it be posted on Monday.
Matters goes away, let it appear on Monday.
Obliged, my lord.
Counsel for the appellant seeks accommodation with the matter appear on the same meeting on 4th August.
Obliged.
My lord, I am appearing for the petitioner appellant in this matter. This is against, my lord, order passed by the Central Administrative Tribunal. My item number, this is, my lord, item number 10.
Yes,
So my lords will see the order passed by the Central Administrative Tribunal begins at page 19. My lord, according to me, my lord, in my humble submission, the order is completely unreasoned because, my lord, what has happened in this case?
let us have the files, give us a minute.
Yes, I'm not referring to the pages yet, my lord. I'll just give a brief overview, my lord. May I submit, my lord?
Yes, yes.
My lord, what has happened in this case is, my lord, an initial order was passed by the disciplinary authority and an appeal was preferred against that order. Now, there were certain directions, my lords, to dispose of the appeal because this appeal went to the president. So, my lord, there was direction to dispose of the appeal. The appeal was not disposed of. Now, when the appeal was not disposed of, my lord, the tribunal has said that not only the appeal abates, but, my lord, the tribunal has said that even the initial order and everything goes because the appeal has not been decided. Now, my lord, that, my lord, in my humble submission is erroneous because, my lord, if the even assuming that the law that has been referred to by the CAT, my lord, even if the appeal abates, the merits of the matter have to be gone into because, my lord, in the original application also they are challenging the same order which was challenged in appeal. So, my lord, the tribunal has to satisfy itself that the order is erroneous rather than just saying that because the appeal abates, so the original order also goes. Now, kindly see, my lord, the facts are all stated in the order. Page 19 is the order passed by the Central Administrative Tribunal. My lord has page 19.
Yes, yes.
This is 20th March 2025. Now, kindly see, my lord, the applicant has approached this tribunal under section 19 of the Administrative Tribunals Act, praying for the following relief. A, to quash and or set aside the impugned memorandum of charge sheet dated 15th March 2021 issued by the Lieutenant Governor, Andaman and Nicobar Islands, acting as disciplinary authority against the appellant with 7 articles of charges without providing listed documents and list of witnesses, which was communicated to the applicant by the Office of Chief Engineer, Andaman Public Works Department, with a office order dated 18 March 2021, by imposing a vague allegation without any evidence and without providing copy of CVC's first stage advice, which under any circumstance cannot be sustained in the eye of law, being Annexure A17 of this original application, the impugned charge sheet dated 15 March 2021 is not maintainable in view of the landmark decision of the Honorable Supreme Court in the case of SBI versus DC Agarwal and CVC's instruction dated 20th September 2000. B. To quash and or set aside impugned office order number such and such dated 21st October 2019, by which the order of suspension has been issued by the Lieutenant Governor against the applicant without assigning any reason, being Annexure A11, and subsequent extension orders of said suspension orders issued by respondent authority, being Annexure such and such of this original application, whereby suspension has been continuing for an unlimited period with effect from 2019 in violation of the decision of the Honorable Supreme Court in the case of Ajay Chaudhary. Under any circumstance, extension of suspension period beyond 3 months, even after issuance of charge sheet, such extension order is not permissible. Then likewise, my lord will see prayer C is the impugned inquiry report has been challenged. Then my lord will see prayer D. Similarly, my lord, order issued by the Lieutenant Governor is challenged. Then prayer E says that the allegations leveled against applicant in impugned charge sheet. Then these are the prayers. Now kindly see the facts set out at paragraph 2. The applicant was officiating as executive engineer, Port Blair Municipal Council. He was ordered with a order dated such and such to function as executive engineer, Zilla Parishad, South Andaman, in addition to his regular charge. The applicant assumed the charge of executive engineer, Zilla Parishad, South Andaman on 14 December 2010 and continued till 28 August 2013. Once again, the applicant was transferred to Executive Engineer Zilla Parishad South Andaman with a office order dated 29 February 2016 from APWD and reverted back to APWD. The applicant was granted regular promotion by an order dated 12th April 2019 with retrospective effect. With a office order dated such and such, the Lieutenant Governor issued an order of suspension against the applicant. The suspension was extended by Lieutenant Governor from time to time on the recommendation of the review committee. The Lieutenant Governor, acting as disciplinary authority, issued memorandum of charge dated 15 March 2021 against the applicant with 7 articles of charge. The applicant, with a representation dated 1st April 2021, denied and disputed all the allegations leveled against him in the said charge sheet. Thereafter, disciplinary authority appointed the inquiring authority and the presenting officer to inquire into allegations leveled against the applicant in the said charge sheet. The inquiring authority submitted the inquiry report to the disciplinary authority on 29th April 2022, whereby he has proved the charges leveled against the applicant in articles of charge 1, 2, 4, and 7 in the charge sheet. The applicant submitted a detailed representation dated 6 July 2022 to the disciplinary authority. The disciplinary authority imposed penalty of dismissal from service within the impugned order dated 23rd July 22. The applicant moved an original application before this tribunal. By the tribunal, by an order dated 3rd November 22, granted liberty to the applicant to file a statutory appeal. The applicant filed an appeal on 18th November 22, which was not disposed of by the appellate authority within the statutory period of 6 months, hence this OA. The applicant had earlier approached the tribunal with a OA number such and such, which was disposed of by the tribunal with a direction upon the applicant to file an appeal before the appropriate appellate authority. Accordingly, the applicant filed his appeal before to the appellate authority on 18 November 22. Since this appeal was not decided by the appellate authority within 6 months, the applicant filed an OA in this tribunal, which was disposed of on 7 July 2023 with a direction to the respondent to dispose of the applicant's appeal within 3 months. The applicant was given liberty to revive the OA if his grievances persisted. The respondent did not take a decision. This is the precedent of India, my lord, on the applicant's appeal within the stipulated time laid down in the tribunal's order. Exercising the liberty granted by this tribunal, with a order dated 7 July 2023, the OA has been revived. The tribunal finally disposed of the OA with its order dated 6 June 2024 with the following directions. In view of the facts of the case and above quoted judgment of the Honorable Supreme Court in State of Karnataka versus Umesh, we deem it fit to direct the respondents to dispose of the appeal in light of our observations above within a period of 3 months from the date. A copy of this order is received in this office. Respondents are further directed to pay to the applicant his dues for which he may be eligible after consideration of his appeal dated 18 November 22 within a period of 2 months thereafter. The order of this tribunal has been set aside by the Honorable High Court in WPCT number 38 of 2024 with the following observations. This court is of the view the tribunal has acted in abdication of its responsibility once an application is filed under section 19 of the Administrative Tribunals Act before the tribunal by reason of subclause 4 of section 19 of the Act of 1985. All departmental remedies appeals automatically abate. The tribunal failed to appreciate the same. The tribunal ought to have either taken up the matter on merits or simpliciter follow the advice and opinion of UPSC insofar as quantum of punishment imposed on the petitioner is concerned. This court has offered to the petitioner through his counsel the recommendation of UPSC as recorded above could be granted by this court if he agrees to the same, with which the counsel of the petitioner has declined. Therefore, impugned order dated 6 June 2024 is set aside. Tribunal shall take up the matter on merits and dispose of the same as expeditiously as possible within a period of 8 months from the date of receipt of the copy of this order. The learned counsel for the applicant submits that with a office order dated 21st October 2019, the Lieutenant Governor issued an order of suspension against the applicant without recording any reason for suspending him from the service as an executive engineer. The extension of suspension beyond 3 months must be by a reasoned order, otherwise it cannot be extended. The government through DOPT has issued consolidated instructions on suspension which clearly says so. That with a order dated 17 January 2020, respondent authority has failed to issue the charge sheet or to give any reasons and extended the period of suspension against the applicant, which under any circumstance cannot be permitted by law. Again, with a office order dated 15 July 2020 and order dated 8 January 2021, the respondent authority extended the period of suspension against the applicant twice for another 180 days in violation of decision of Honorable Supreme Court in Ajay Chaudhary. Learned counsel for the applicant submits that respondent authority in violation of landmark decision of the Honorable Supreme Court by not explaining the inordinate delay from the cause of action arose and also by not providing the CVC's first stage advice in violation of CVC circular dated 28 September 2000 issued an impugned memorandum of charge on 15 March 2021. On perusal of said charge sheet, it is evident that list of documents as well as list of witnesses are vague. On these grounds alone, the impugned memorandum of charge sheet dated 15 March 2021 cannot sustain in the eyes of law because no detailed list of documents has been provided and name of the connected witnesses are missing in the said memorandum of charge sheet. Learned counsel for applicant submits that on the 4th day of inquiry on 21st January 2022, the inquiring officer authority, without calling for witnesses or respective documents produced by the prosecution, marked all documents not listed in the list of documents of the charge memorandum as exhibits, and no opportunity for cross-examination of authors of those documents was given to the applicant in violation of the principles of natural justice. On 2nd April 22, applicant's general examination was carried out by the inquiring authority in violation of Rule 1418 of CCA rules and also in violation of DOPT instruction. Learned counsel for applicant submits the applicant was not allowed to cross-examine most vital witnesses in the said proceeding, and most of the listed documents which the applicant had asked for has not been supplied to the applicant, and most of the articles of charge based on which the impugned memorandum of charge sheet was issued were not supported by any evidence. Learned counsel for the applicant further submits the inquiry report is absolutely arbitrary and illegal, and there are lacuna and latches in respect of conducting such inquiry proceedings in violation of CCA rules 1965 and also by violation of the decisions of the Supreme Court in Roop Singh Negi and Prakash Kumar Tandon, and on such grounds and verdict of Supreme Court, impugned order under challenge are not acceptable in the eyes of law and also gross violation of principles of natural justice. Learned counsel for applicant submits that without considering the submissions made by the applicant in the said representation and by placing reliance upon the one-sided inquiry report dated 29th April 22, disciplinary authority passed a final order imposing penalty or dismissal from service in gross violation of the amended Rule 15 and also in violation of the Honorable Apex Court's decision in the case of Union of India was S.K. Kapoor. Learned counsel for the applicant submits that applicant being a Group A officer, disciplinary authority is bound to take advice from UPSC after receiving the inquiry report, and by skipping that procedure, the disciplinary authority has committed a gross illegality. Therefore, the order dated 23rd July 2022 is to be set aside. By CVC circular dated 7 December 2012, it is mandatory that mandated the second stage consultation in all disciplinary proceedings, disciplinary cases of Group A officers necessary. Learned counsel for the applicant submits the charges framed under such and such are for the duties in Zilla Parishad that revolved around the date of 6 January 2010, on which date applicant was not an employee of Zilla Parishad. As such, by no stretch of imagination, any misconduct can be made out, and those charges are framed after inordinate delay of 11 years, which is also not permissible. Learned counsel for the applicant submits that no misconduct can be made out against the charges alleged against articles such and such on the applicant, since the applicant is not the authority in Zilla Parishad to take any decision on financial matters for challenging an arbitration award on alleged grounds mentioned in the impugned charge memorandum, when a decision contrary to alleged ground has already been taken by the head of the institution, that is Adhyaksha Zilla Parishad, almost 6 years before the issue of charge memorandum and about 3 years before the issuance of arbitral award in question. Learned counsel for the applicant submits that disciplinary authority imposed a penalty in an illegal manner. Disciplinary proceedings already initiated could have proceeded after the applicant's superannuation, but was hastily concluded. Inquiry authority's finding is based on no evidence. Now, kindly see the submissions of the respondent. Learned counsel for respondent submits that after conclusion of disciplinary proceedings against the applicant, a major penalty of dismissal from service was imposed upon him by disciplinary authority by penalty order dated 23rd July 22. Learned counsel for respondent submits that applicant did not prefer a statutory appeal before the appellate authority, that is President of India, as prescribed in CCS conduct rules, and directly approached the tribunal in violation of CAT rules and procedure. The tribunal disposed of OA such and such by an order dated 3rd November 22 and directed the applicant to prefer statutory appeal before the appellate authority. The applicant preferred statutory appeal on 18 November 22 through proper channel. Rule 25 of CCS CCA rules categorically specifies that no appeal preferred shall be entertained unless such appeal is preferred within a period of 45 days from the date on which a copy of the order appealed against is delivered. However, appellate authority entertains the statutory appeal even after a period of 115 days. Respondents in their reply submit that the applicant, on completion of 6 months after filing of statutory appeal, immediately approached the tribunal by filing OA to interfere with the order of dismissal on merits. The tribunal disposed of the same by an order dated 7 July 23, directing upon the respondent competent appellate authority for disposal of statutory appeal within 3 months. A Ministry of Home Affairs with a mail dated 19 September 23 directed, because the Ministry of Home Affairs, my lord, procedurally handles the appeals filed before the President, directed the administration to file an application seeking extension of time for disposal of statutory appeal, as statutory appeal was forwarded to UPSC on 18 September 23, and UPSC normally requires 6 months to render an advice. The department filed a MA seeking extension of time before tribunal, which was rejected, and by the same order, such and such was restored. The applicant agreed by order of tribunal, approached High Court by filing writ petitions disposed of. In the meantime, UPSC rendered its advice with a communication letter dated 6 December 23 to MHA, which was forwarded to the party through proper channel for their comments. The applicant with a letter dated 24 January 24 replied to the MHA letter dated 15 December 23 and submitted the same to Secretary MHA New Delhi, and a copy to disciplinary authority through Vigilance Department, ANN Administration, for furnishing parawise comments, and the Vigilance Department, ANN Administration, in preparing parawise comments. The parawise comments, once prepared, shall be forwarded to Ministry with approval disciplinary authority for further action. Learned counsel for respondent submits instant OA is not maintainable in view of necessary parties being not impleaded. Vigilance Department is a nodal agency for all disciplinary proceedings. The Vigilance Department provides necessary inputs for disposal of statutory appeals. So Secretary Vigilance is primary respondent in any disciplinary proceeding, and in absence of Secretary Vigilance, the OA is not maintainable. Learned counsel for respondents further submits that suspension order was extended based on recommendation of suspension review committee. UPSC in its advice has observed that due procedure as prescribed has been followed while conducting the inquiry proceedings against the applicant. UPSC has observed that article of charge against applicant that he did not take appropriate steps to challenge arbitration award was established based on other documents on record, and report of CEO, even if excluded for purpose of evaluation of charges, does not make any difference in the findings in case of specific charges held proved against the applicant. Learned counsel for the respondents further submits that it's also been clarified by UPSC that applicant is holding Group A post of executive engineer as per Gazette notification. Lieutenant Governor is the appointing authority for the post of executive engineer in ANN Island. Therefore, consultation with UPSC was not necessary before imposing any penalty on applicant by disciplinary authority. UPSC has categorically observed that in the instant case, due procedure as prescribed under the rules has been followed while conducting the inquiry proceedings against the applicant, learned counsel for respondents further submits the disciplinary authority has imposed a major penalty of dismissal from service, which shall be a disqualification for future employment under the government. And as per Rule 41 of CCS pension rules, the applicant shall forfeit his pension and gratuity. There is no rule permitting provisional pension to a dismissed government employee, and as such, applicant is not eligible for grant of provisional pension till his penalty order of dismissal in service is. Now, kindly see the findings. Heard the parties peruse material on record. Respondents have raised the issue of maintainability of the OA on 2 counts in their reply. According to the respondents, the time limit for filing the statutory appeal against the order of disciplinary authority is 45 days from the date of the disciplinary authority's order. Without exhausting the remedy available to him, the applicant rushed to the tribunal praying for quashing of the disciplinary proceedings against him in violation of Section 20 of the Administrative Tribunals Act 1985. While filing OA such and such. However, the respondents have fairly admitted the liberty was granted by the tribunal to file the statutory appeal, which was 115 days after the disciplinary authority's order was passed. Respondents in their reply have also submitted that the appeal of the applicant was entertained by the appellate authority, since Section 20 of the Administrative Tribunals Act also gives power to the tribunal to consider an application at its discretion, even in cases where all available remedies have not been exhausted by the applicant. The tribunal, in exercise of this power, gave the liberty to the applicant to file an appeal before the appellate authority even after the expiry of 45 days from the date of the order of disciplinary authority was passed. Appeal was therefore rightly processed. Respondents also submitted that OA is liable to be dismissed for non-joinder of parties. They further submitted that Vigilance Department of Administration through its secretary should have been added as respondent in the OA because remarks of the administration on the representation of the applicant against UPSC advice was being prepared by Vigilance Department. The proceedings against the applicant was started at the behest of the Vigilance Department. Therefore, non-joinder of renders the OA non-maintainable in its present form. From the records, it is seen that the suspension of the applicant by the Lieutenant Governor, who as disciplinary authority issued the charge sheet, appointed inquiry officer and issued the punishment order. Lieutenant Governor has been made a party. Other officers like APWD Secretary, the organization where the applicant works, have also been impleaded. We do not consider the Secretary Vigilance as a necessary party, and his absence from area of respondents has no effect on maintainability. In view of the discussion, it is held that OA is maintainable. It is noted. Now, this is what has been decided by the CAT. It is noted at the outset the respondents have repeatedly failed to comply with the directions of this court to dispose of the appeal by the applicant against the order of dismissal imposed by disciplinary authority. Honorable High Court in its order in WPCT 38 has directed tribunal to consider the matter on merits. The Honorable High Court, while disposing of OA on 11 November 2024, had the occasion to discuss the merits of the case. Our findings in the matter as given in our order dated 6 June 2024 are as follows. From charge memorandum dated such and such, inquiry report and disciplinary authority disciplinary authority's punishment order, it is seen that there is no proof of the applicant having made financial gains. Disciplinary authority has dismissed the applicant from service, forfeiting his retirement benefits with a bar on his future employment. In our view, disciplinary authority's order is perverse inasmuch as punishment is grossly disproportionate to the proven misconduct. This has also been appreciated by UPSC in its advice, para 7 and 8 of quoted below. A commission observed that in the instant case, due procedure is prescribed and the rules has been followed while conducting inquiry against the appellant, while imposing the penalty of dismissal from service, which shall be a disqualification for future employment. DA has held that articles 1, 2, 4, and 7 are proved against the applicant. However, as per analysis of the case, Article 4 and 7 against the appellant, Article 2 is partly proved and Article 1 is not proved against him. In view of the above, there is some merit in the appeal preferred by the appellant. Apart from this, there is no allegation or evidence to suggest that appellant had connived with the contractor with malified intention for some motive or his personal gain. Hence, the penalty imposed on the appellant by the DA needs to be reconsidered. In light of observations and findings as discussed above, and after taking into account all other aspects relevant to the case, the Commission observed that penalty of dismissal from service shall be a disqualification for future employment under the government earlier imposed upon the appellant was excessive, and the same may be modified to compulsory retirement with effect from the date of dismissal, along with withholding of 30% of the monthly pension otherwise admissible to him for a period of 5 years. The gratuity admissible may be released if not required to be withheld in any other case. In our opinion, the applicant has unfairly subjected to a harsher punishment that deserves for a fairly long period, much of which is also to the inordinate delay in disposing the appeal. In view of the facts and the judgment in such and such, we deem it appropriate to direct the respondent to dispose of the appeal in light of our observation within a period of 3 months from the date. A copy of this order is received in this office. Respondents are further directed to pay the applicant his dues, which he may be eligible after consideration of his appeal within a period of 2 months. No appellate order was passed in spite of repeated directions. Learned counsel for the applicant has cited a reported judgment of this tribunal passed by Coordinate Bench of Ahmedabad in the case of Shiv Kumar Nair. In the cited case, Coordinate Bench set aside the entire disciplinary proceedings starting from stage of suspension prior to issue of charge sheet or to the disciplinary authorities order on the ground the representation of the charged officer, the applicant in the OA, was not disposed of by the appellate authority even after 6 months. The Coordinate Bench in its order has extensively discussed the issue in light of constitutional provisions and various judgments. We quote below the relevant extracts from the order of the Coordinate Shiv Kumar. It is clear from section 19 and 20 read together that if an appeal preferred against the order of disciplinary authority is not decided within period of 6 months, then the OA can be filed, and on dismissal, on its admission, the appeal abates. The appellate authority cannot therefore decide the said appeal except with permission of tribunal. It is clear from the foregoing discussion that appellate authority has a minimum of 6 months to decide the appeal. The actual time may be more if OA is filed and registered beyond this period and OA is admitted subsequently. The Government of India instructions provide for expeditious disposal of appeal. If the appeal is not decided during the period or after admission with leave of the court, the appeal abates if the proceedings are treated as synonymous with the appeal. The net effect is that if the word proceeding is construed as synonymous with appeal and the appeal is not decided in time, the same abates and the valuable right of the applicant to challenge the finding of fact of the disciplinary authority is taken away by implication. The importance of the same has been emphasized in Ramchandra's case. This conclusion holds without ascertaining the true meaning of abatement in this section. The word proceeding is not defined in the Administrative Tribunals Act, while Section 19 refers to every proceeding under the relevant service rule. Section 29 refers to proceedings pending before a court or authority. The Apex Court decisions about proceedings under Income Tax Act, Specific Relief Act, disciplinary proceedings in Section 29 leads to irresistible conclusion that word every proceeding under the relevant service rule is an extremely wide term, and which in case of disciplinary proceedings would commence with suspension pending issuance of charge sheet and conclude with order of revisional authority. We find that CCA rules framed in exercise of powers under Article 309 is a special law as far as disciplinary proceedings are concerned. AT Act is a later general law providing for abatement of proceedings. It also does not create an alternative forum for deciding the appeal. We are accordingly of the view that in such case, now this is completely, my lord, unsupported with what is the discussion above. We are accordingly of the view that in such cases, the entire proceedings from the stage of suspension, pending issuance of charge sheet abates. The OA is allowed and the order of disciplinary and appellate authority are set aside. The applicant will be treated as having been on duty from the date of suspension proceeding till its termination. The applicant will be entitled to all consequential benefits. The same will be paid within 3 months. In the instant case, the applicant was allowed by tribunal to file an appeal against the disciplinary authority's order even after expiry of statutory period. The applicant, in pursuance of the court's order, filed an appeal on 18 November 22. Appeal was, however, not disposed of by the appellate authority within 6 months. Therefore, the applicant again approached this court on which was disposed of on 7 July 23 by directing the respondents to dispose of the appeal within a period of 3 months. Since the appeal was not disposed of in statutory period, OA was revived as per liberty granted to the applicant. OA was heard and disposed of with the observation that the punishment imposed by disciplinary authority was disproven, again erroneous. This was only a prima facie observation to the proven charges and with the direction to the appellate authority to dispose of the appeal within 3 months. Keeping in view recommendation UPSC on appeal, this order was set aside. On 12th November 24, my lord, I read the High Court's observation. High Court directed the CAT to decide on merits. Appeal was filed by applicant on 18 November 22. In spite of repeated directions from tribunal, it was not disposed of till 12th November 24 when the Honorable High Court remanded the matter to the tribunal for consideration on merits. In our opinion, facts and circumstance issue in adjudication in Sivakumar decided by are the same. The core issue decided in this OA are whether stage of consideration of appellant's representation was abated and whether abatement of the stage of consideration appeal will result in abatement of entire disciplinary proceedings, including order of suspension prior to issue of charge memorandum. Coordinate bench on Ahmedabad considered the above two issues and passed the following order. Now, this is, I read this already, my lord. Ratio laid down by the coordinate benches Shiv Kumar is squarely applicable. In the instant case, the appeal was neither decided within the normal period to decide appeal, nor has it been decided within the time limit set by this court. Therefore, stage of consideration or appeal of the appellate authority has abated. An applicant has been denied the legal right to challenge findings of fact of the disciplinary authority has been taken away. Following the issue, entire disciplinary proceedings against the applicant from the stage of this suspension pending issue of charge memorandum abates. So, my lord, on this basis, my lord, this OA has been decided. Now, this is in my humble submission, this is completely contrary, my lord, to law, because, my lord, in the event the appeal is not decided, the appeal can abate. That doesn't mean, my lord, that the OA is not, and the High Court has in these very proceedings directed the tribunal to decide on merits. How can the High Court this is in violation of the High Court's order, my lord. The High Court has specifically directed the CAT to decide on merits. And the CAT is saying that because the appeal has abated, so the order under challenge also goes. How can that be, my lord? If the Ahmedabad authorities also, my lord, it is abruptly, my lord, the final conclusion that the order of the disciplinary authority should go. I agree, my lord, if even assuming this principle is correct, that the order of the appeal abates, that is fine. But the OA has to be decided on the merits, my lord. The tribunal then cannot oust the applicant on the ground of alternative remedy. That I understand, my lord. But, my lord, that means that the alternative remedy point cannot be taken because the appeal has not been decided. But the OA itself has to be decided. The challenge which is laid by the applicant to the order passed by the disciplinary authority has to be considered on its own merits. The earlier interim order, some observations have been quoted from the earlier interim order, but the final conclusion in that, my lord, was to again send it back to the appellate authority. And after that, the High Court directed the CAT to decide on merits. So, my lord, those observations are not a final finding on the merits in this OA. So, my lord, in my humble submission, my lord, this order is erroneous, my lord, and the CAT may be directed to consider the matter on the merits, my lords. Whatever they may succeed, that's a separate issue. But, my lord, it has to be considered on merits, my lord. The disorder of the disciplinary authority and ought not to be set aside because the appeal has abated against the same, my lord. This is my submission, my lord.
Yes.
First of all, I want to refer to the Tribunals Act 1985.
Yes.
Read statement of objects and reason. And paragraph 3.
Yes.
Paragraph 3 says that establishment of administrative tribunal under the aforesaid provision of Constitution has become necessary since a large number of cases relating to service matters are pending before the various courts. It is expected that the setting up of such administrative tribunals to deal exclusively with service matters would go in a long way in not only reducing the burden of various courts and thereby time to deal with other cases expeditiously, but would also This is the main object of the Tribunals Act. Now kindly come to section 19.
Yes.
Section 19, subsection 3.
Yes.
On receipt of an application under subsection 1, the tribunal shall, if satisfied, after such inquiry as it may deem necessary, that the application is a fit case for adjudication or trial by admit such application.
But where the tribunal is not satisfied, it must reject the application after recording the reasons. This number 3. Subsection 4 is important in this case, where application has been admitted by the tribunal under subsection 3. Every proceeding under relevant service as to redressal of grievances in relation to subject matter of such application pending immediate such admission shall abate and say as otherwise directed by the tribunal. So tribunal has the discretion to say something otherwise. No, thereafter it says, no appeal or representation in relation to such matter shall thereafter be entertained under such rules. So there is a complete bar after admission. And if the tribunal does not say so, any direction, does not give any direction, then there is a complete bar under the Administrative Tribunal Act 1985. So, my lord, in this case, what has happened? First OA was filed by me in 2022, just after the dismissal order, because that dismissal order was ex specie illegal just before 7 days retirement. I was due for retirement on 31st of July 2022. I was dismissed on 23rd July, just 7 days before. And that the dismissal order was illegal because the procedure prescribed in Rule 15 of CC rule was followed. So that immediately made a representation to the disciplinary authority first, because there is a government OM which specifies that in such cases of hurriedness, that order of disciplinary authority is to be set aside, and the if the charge officer is already retired, then that period should be treated as he is on suspension, if he is on suspension, and he should be given the pensionary benefits. So only for that purpose, I moved the first application. I will show the OM, government OM, what it says, if your lordship wants.
I think we are not really on merits of the
Because
case, right?
the respondents are insisting upon merits, so that's why it becomes my
We
duty.
dealt with, not at this stage. The first application, the tribunal sent it for submission
Okay, okay, ma'am.
within 6
I will. So now, at that time, in the tribunal's order also, I have said that I may be given an interim relief, that I may be given provisional pension. That's why I have come before you. So tribunal said, we will not give that relief. If you want, you prefer an appeal, and in the appeal, you ask for an interim relief. So accordingly, I prefer the appeal with an interim relief saying that I may be given provisional pension till the disposal of appeal. So appeal was not disposed of 6 months. There is a constitutional bench judgment which fix the outer limit to fix the outer limit to dispose of the appeal of
Within
6 months. 6 months. So, and also the this 20 section 22 of Administrative Tribunal Act also gives us the remedy to file an OA. So interpreting this section 19 and 20, the constitutional bench has said that order limit is 6 months. So I moved the second OA, challenging the entire prior. It's recorded in the order itself, impugn order itself. So I preferred an OA. So when I preferred the OA at the admission stage, tribunal was of the view that we give some more time to them. When I filed the appeal, in the appeal itself, first order of tribunal was annexed, and I have sent it. That with the permission of tribunal, I am filing this appeal. So they are already aware that I have moved the tribunal, and after 6 months, my second application was notices were served to them that I am going to file this OA. So all parties were represented in the OA. 7th of July 2023, the authorities were given 3 months time. The appellate authority was given 3 months time, more time. I waited. I accepted that order. I wait. After 3 months, as per the liberty granted by tribunal, I moved a MA for revival of my OA. My OA was revived. And thereafter, the authorities filed a seeking extension of time, my lord. So, my lord, that extension of time application was rejected by the tribunal because they have not complied with the direction of that time. And that order was never challenged before the authority. The rejection of extension of time was rejected. That extension of time application was rejected
By this court.
by the tribunal. The order was never challenged before any forum till date. So what happened? That time itself, I made a submission that as per section 19(4), I should get my benefits because 19(4) says every benefits. But the tribunal did not decide it on that point, that time. Then because they did not decide in that circumstance, I moved a writ petition. And that writ petition's order is at page number 763.
Third volume.
Volume 4.
Fourth volume.
There is a specific submission, but it is not getting admitted.
Yes, so the tribunal was directed to deal
Deal
with
with.
merits.
Yes, my lord. So now, after that, I went back to tribunal. Tribunal. Thereafter also, tribunal not decide. Thereafter, on 6th of June, 2024, tribunal decided the matter on merits. On merit, it was decided. 6th March, that order is there, 6th March, I will show you, my lord.
Where is
6th of June 24 is at page 862.
8, volume 5.
Volume 5, page 862.
volume 5?
Page 862.
Yes, my lord, 862. This is the first proposal on merits.
After the order of this court.
First order. That order just now is shown.
Yes, yes.
After that, this was disposed of. In this, from 5.1 onwards, I will read, madam. By its order dated 7th July 2023, the bench had directed the respondent to dispose of the appeal of the applicant within 3 months. It is seen from the record that it was brought by the appellate authority on 9/23. This is the first time they are sending a letter My appeal is of 18/11/2023. After almost 10 months, and applicant filed his appeal more than 2 months after the tribunal passed its order. An application praying for extension of time to comply with the orders of the tribunal was turned down by the tribunal on 1/12/2023. The reply filed on 2024. The respondents have stated that matter was pending with Vigilance Department of Administration for preparing their remarks on representation of applicant dated 21/1/2024. This is the representation which I have sent to UPSC because UPSC has given some advice and that was given to me. I will come to that, but this is that representation. The process of disposal of appeal by appellate authority has been, and this recording is the matter is pending with Vigilance Department. The status is as on date. In the writ petition also, that statement is same. It is pending in the Vigilance Department for pending remarks. This may kindly be noted. Though it's there, that is the statement affirmed on oath. The process of disposal of appeal by authority has been agonizingly slow, even after considering the fact that appeal is to be proposed by the Ministry of Home Affairs. Applicants fate hang.
On merits.
No, madam, I'm reading.
Please come to 867. These are the facts stated.
Yes, my lord. That's
5.4.
yes, my lord. And direction was given to dispose of the appeal. The facts are stated clearly. And they have also come to a conclusion that
So the
Purpose.
deal with merits of the case.
who will decide
It's
the,
again referred.
my lord, who will decide the appeal? This is the question which I am asking to myself. Who is the authority to decide the appeal in this case? Not the court. It is the appellate authority. And
Yes.
appellate authority happily allowed this appeal to be abated. They have allowed. If there is an order or not an order, inaction, both are orders of the appellate authority. They not taking any action against the disciplinary authority's order only because they know that all the entire sequence of events are illegal, contrary to law, contrary to the government of India. So they are not deciding it. And they have rightfully not decided only with the intention that in section 19(4), tribunal says the entire proceeding abates. That is a decision of appellate authority. It is not that there is no decision.
My lord, this order has been set aside by the High Court at page number 869. This order has been set aside by the High Court. I don't know how the tribunal and even the other side is relying upon this order. Kindly see 868, 869.
Then they did not prefer any appeal against that order. 6/6/2024. 3 months time was given. 3 months time was given in that expired in September 24. Because that is contrary to 19(4).
There was a specific direction in this order that the tribunal shall take up the matter on merits and dispose it of as expeditiously as possible.
Yes, my lord.
So it was not taken up on merits.
My lord, the merit is 19(4). What will happen to 19(4)? That is my question to myself. What will happen to 19(4)? That is the merit of the case. Because no appeal was, no decision was taken by appellate authority. Tribunal cannot sit as an appellate authority. The tribunal must do it only the judicial review. They cannot sit as an appellate authority to decide the entire appeal. That is my contention, my lord. Subject to
The tribunal to deal with the matter on merits. So in view of such direction, the tribunal, I think,
my lord, 19(4) is clear. As per law, tribunal cannot decide the appeal. Tribunal cannot decide the appeal. 19(4) is very clear. It cannot override 19.4. Tribunal cannot override 19.4. Even otherwise also, that is in the reply, they have contributed any of my pleadings. I will come show their reply. They are saying, how can they call everything on merits now?
In fact,
Reply is at page number 871.
Challenge this order of the High Court,
Which order?
which says that the tribunal will take up the matter on merits.
My lord, my respectful submission is, tribunal has taken up the entire matter on merits. They have made all submissions.
They take up on merits. I do not find any observation.
Tribunals have decided, tribunal has decided the entire submission, what submission I made. It is recorded. And thereafter, tribunal has taken up those submissions which was made by the respondent. Respondents made the submission only on account of non-jointer of party, that is Secretary Vigilance. And they have also taken the point.
Is the decision on merits?
Yes, my lord. The tribunal has given finding on the submissions of the respondents. That is their
Yes.
finding.
The findings of
Because none of the points raised.
and at
Suspension order revised.
yes.
in fact, the tribunal at para 5.3 at page 32
But the tribunal has taken up the matter on merits.
Every proceeding abates the wording of 1940.
in fact,
Proceeding started with the authorities abates. Every proceeding means right from suspension. That is also a proceeding. That is also under challenge. That also abates. That is what the 1946. And my lord, kindly come to the impugned audits. Because in the reply, neither in the reply nor in their submissions, they have controverted to the illegalities which are committed by disciplinary authority. Because I don't know, they have preferred not to say anything on that. So that means law says if anything is not remains uncontroverted, it is to be deemed to be admitted. So they have not controverted. They have raised only 2 points. And which was decided. Impugned order is page number 19.
Yes.
Page number 30. Page number 30 is the relevant page.
Yes.
Now, whatever submissions it is recorded, and submissions they made to the tribunal, that is also recorded. And 5.1, respondents have raised the issue of maintainability of OA. They have raised only these points, which are taken up. According to the respondents, the time limit for filing the statutory appeal against 45 days, and this they have allowed, which has filed 150 days after the disciplinary authority's order was passed. Respondent in their reply also submitted that appeal of the applicant was entertained by appellate authority. Now, after that, this is court's finding. Section 20 of Administrative Tribunal Act also gives the power to tribunal to consider an application at its discretion, even in cases where all available remedies have not been exhausted by the applicant. This is the finding of court. The tribunal, in excess of power, gave the liberty to the applicant to file an appeal before the appellate authority, even after the expiry of 45 days from the date of order. Disciplinary authority was passed. Appeal was therefore rightfully processed by the respondent. This is one contention which they have raised. Second was, respondent have also submitted that.
Not joiner of the three parties.
None. That finding is also given. It is not required because all orders are passed by this.
These are not on merits. These are with
These are the-
ability.
My lord, kindly come to the reply which they have filed. How can tribunal go beyond the reply? Which is a question I am asking to myself. reply is at page number 871. 871, volume 5. Tribunal cannot go beyond file this reply.
Yes,
871.
yes. Yes,
Tribunal, these are the various facts which were pleaded, not maintainable is the issue. That the applicant was issued with charge memorandum for not properly handling the arbitration matter. So now this is the first their objection. Arbitration matter. So my view is handling an arbitration matter was not within the authority of this applicant, and there were Adhyaksh Jila Parishad who has already handled the matter and made the payment. This applicant is not the authority to release the payments. So that was and arbitration, dealing with arbitration matter is not at all a misconduct at all. J. Ahmed's case will come in this queue. It is not a misconduct at all. It is a part of official duty. He was doing an official duty.
that is again on merits.
Yes. That after conclusion of disciplinary proceedings against the applicant, a major, so that was perverse order. Tribunal has already given their finding that it is a perverse order. Disciplinary authority's order is a perverse order.
Where is that finding?
Impugned order itself. But after that, I preferred an appeal before the Honorable High Court, and it was set aside. But they have quoted that finding in the order passed subsequently. That impugned order is page 19.
Yes, the earlier was
Set aside, but again it was quoted, re-quoted. Page 19.
the earlier order that you're referring to, that was set aside, the 6th June order.
June order was
Before was set aside,
set aside.
and there was a direction for dealing with the matter on merits.
Merits.
Where is that compliance?
Yes, madam. This is this order.
After the present order was passed.
Present order, in that they have said that we have already disposed the matter on merits, which is quoted below. They have given it.
Order set aside by the High Court is cited again by the tribunal saying that we have already decided on merits, and this order, despite the fact that it was set aside and sent back.
Oh,
Page number 32.
it's to be a decision on merits?
Page number 32.
Yes.
32 has directed the tribunal to consider the matter on merits. Honour High Court, while discussing the OA on 11/11/4, had occasion to discuss the merits of the case. Our findings in the matter as
The
given.
findings which were set aside have been repeated in
Yes,
this order.
Yes, madam. Yes, madam.
That
But
could-
it has come again.
that
But
could
in
be
this,
repeated.
in
A
this,
fresh consideration was required.
it is the High Court order speaks about abatement only. Kindly come to the
Abatement and dealing on in merits.
dealing in merits.
Oh,
Dealing in merits. So this was merit. They have quoted this, that in our previous order, which dealt with our previous order.
that was
That-
already set aside. That no
Yes,
longer
yes, madam.
remains.
I understand.
When the order
Understand.
impugned
Yes,
was
yes,
passed, the earlier order was
I
not there.
accept, I accept.
Despite
accept.
which they have quoted it.
That's
There
right, which-
need to have been a fresh consideration.
Yes, my lord. I'm coming to that. I have not finished it. I need some time. I can be taken up tomorrow also, no issue. this shortage of time.
Please come back tomorrow.
Yes, my lord.
My lord, my lord.
Tomorrow is 31st July.
has been disposed of. These 4 matters can be disposed of in the line of the, this, not so that I want the
Let me
inclusion.
take the list tomorrow.
Yes, ma'am. These 4 matters.
Mention. My lord, I may be allowed to mention one matter,
Yes,
my lord.
yes.
Proceedings are completed. Liberty was granted to the petitioner to make submission before this honorable court. The proceedings are completed. I pray that
Yesterday also you made the same submission. I think.
Yes, my lord. This is subsequent different matter, my
Oh,
lord.
this is a different one.
Yes, ma'am.
Let me hear it.
Yes, ma'am.
Is mentioned in the list? Item six.
Yes,
Item,
follow.
item number 1.
Lord,
Item NDPS 6 of 2025.
Lord, I am for the petitioner. Lord. I am for the respondent, Lord. Lord, this is a application for bail. Lord, the facts of the case is that the petitioner, there are 2 petitioners, my Lord. They, as per the prosecution, they are to be studying the husband and wife.
Give me a minute.
আচ্ছা।
এটাকে একটু 24 বা 25 করুন। আবার সকালে তো ঠিক ছিল আবার কি হয়ে গেল? না? এমনি করুন, 24 আর দুটো। বাবা, 24 25। হ্যাঁ। Yes, continue.
My Lord, they, as per the prosecution case is that they have made a search in the premises which belongs to the petitioner number 1 and 2. They found 6 plants, small plants of
Copy.
cannabis plants. And subsequently, they made a subsequent search. They found some powder substance. It's suspected to have been meth.
There is only one petitioner here, 6 and 7 you are.
My Lord, has the supplementary list has just come, my Lord, and the other matters. Other matters come in a supplementary list. My Lord, they say that the powder substance which is to be suspected as to be meth. So the charge sheet investigation has been done, charge sheet has been filed. No, this is a bail application, it is not, I have to show them not the exception to section 37 of the NDPS Act because this is a bail. Lord, may kindly come to page number 42 once, my Lord.
Yes.
Lord, this is a brief details as under the contents which have been seized. FIR.
Charge sheet?
Yes, well, this is the charge sheet. Part of the charge sheet is the SDPO report, my Lord. Inspector Vijay Kumar SHO report. My Lord, we see bottom. The signature of the Inspector Vijay Kumar SHO PS Diglipur. My Lord, will see name of the agency PS Diglipur, name of the drug seized, quantity seized, 6 number of cannabis plants wrapped in a white paper, 1 plant of height 28 centimeter and rest 5 number 15 centimeter height, approximately weight about 12 grams. 2 numbers of transparent polythene bag containing 4.64 kg and 1.64 kg of white color crystalline type powder substance of suspected to be methamphetamine and 4 numbers of mineral water bottle containing white colored crystalline type of powder substance.
The report is on record?
No, my Lord, this is my case, my Lord. The Honorable Trial Court, without the CFSL report, whether that is suspected to be treated to be as a myth or not, they have not taken into consideration. My Lord, will see the rejection of the bail order. My Lord, may kindly
So
come.
the report is not, has not yet come?
Not yet come, my Lord. This is my first submission, my Lord.
You're
And my Lord,
ready for how long?
my Lord, from the 25th January 2025 till today, my Lord. I am in judicial custody and the court has rejected my bail on the count that the court treated this as a methamphetamine. But the charge sheet, it says it is suspected methamphetamine without any CFSL report. My Lord,
The trial court will decide, not the.
no, that's right, my Lord, because the report has not come. CFSL report has
We
not
need
come.
to wait for the report.
My Lord, the trial has commenced.
So this is not rebuttal of 37.
My Lord, may kindly see, my Lord, I just shows certain judgments. My Lord, this honorable court has granted based on this aspect. If my Lord will see, my Lord, they say this is suspected to be meth. My Lord, until unless a charge has been framed based on the CFSL report, how can, my Lord, the trial court has come to conclusion that it is a meth and I am proceeding with the charge based on this. Either the trial court should not have framed the charge. The trial court has framed the charge and proceeded the further.
Oh, evidence has started.
Yes, Mona, proceeded further. One evidence has already been, so far I have instruction, but is Northern India and the one evidence has already been concluded.
You're
But-
not annexed. Where is the charge?
Mona, the charge has not been enclosed. I have enclosed the bail order, which is at page number 91.
Let me hear the state.
Lordship, credible information was received by the police.
Where is
That's
the
a,
FSL report, sir?
Lordship, it is not available at Port Blair. It was sent to CFSL Kolkata because in Port Blair only FSL is there. Regarding testing of methamphetamine or other articles, it is not available.
When was the case started?
Case started on 26 January 2025. We are on July, Lordship.
When did you send the
Lordship.
material for examination?
No, just a minute, Lordship.
No, with due respect, no, this aspect with regard to the methamphetamine sent to the CFSL, nothing was whispered in the charge sheet. Only the
It is-
Canadian,
See.
yes,
Let us-
only with regard to the Canadian, the local CFSL has given a report. With regard to this suspected meth,
5th
when-
February 2024, 5 with forwarding note. Forwarding note sent to CFSL Kolkata, 5th February 2025. Immediate, 26 January, FIR registered, seized. Then 5th February 2025
For CFSL.
for CFSL Kolkata for methamphetamine test. Regarding
Yes.
cannabis available here, charge sheet already filed. That report is there along with the charge sheet. Here, Lordship, may I? Credible information received by the police that there is a ganja planted in the house of these two petitioners. They are the husband and wife. Lordship, what happened? Police immediately rushed to the spot. And that plan, 6 number plans founded just in front of the house of these two person in a dark shed. There is a duck farm in front of the house. Duck farm. Inside the duck farm, there is one jar. 6 number of plants. It means intention in honor. If it was in open ground place, in grasses place, we can say that it is by naturalization or going some other ways. But kindly see in the jerry cane, 6 plants. It means they have full knowledge, husband and wife. They have planted, immediate seizure was made. Then after interrogation and search of the house, Dinobandhu was not present at that time. He went for fishing on that day. It is admitted position. Wife was present. When the house of these accused persons were searched thoroughly, more than 30 kg that sugar, that methamphetamine have been seized. Thereafter it was it, Lordship.
Not
uh,
30, 13, 1.
13, 1, 3. Lordship, more than 50 grams is the commercial
Yes,
quantity.
yes.
So kindly appreciate this part. We are residing in isolated islands. Many cases in connection with methamphetamine, many cases are pending, many arrested have been done. Lordship, regarding that report CFSL, it is not a fault of the investigation officer. Immediately on 26 January, FIR lost, seized was done. 5th February, we have sent to the CFSL. Overloaded there, only 4 or 5 CFSL within in India. Here are no available facilities. So, Lordship, my humble submission at this stage commercial, and there is a bar under section 37, reasonable suspicion. So, I humble pray at this stage, this petition should be rejected.
Yes.
not,
Can you reply?
not in the charge sheet, not my page number 19. They say that they sent CFSL due to error. They have not able to get the CFSL report. My lord, in the entire charge sheet, they have only to the extent of the Canadian links which was sent to the CFSL on 28th February 2025. And after a period of 1 month, my lord, because they have been done on 25th of January 2025.
This has to come from Calcutta and there has been prime seizure from you.
No, that's why not the under the Narcotics and Substance Act, not the rules have been framed, whereby it is specifically mentioned that not within 15 days. Lord, I understand, Lord, with regard to the methamphetamine, if it is a methamphetamine, I will not make any assumption. But when the prosecution itself is saying, the investigation officer itself, it is a suspected meth. Until unless when it is to be shown
They
that it is.
cannot say that it is. They will say it is suspected until the report comes.
That's why, my lord, because
They
they
are
have a
not
kit, they
position.
could have been tested in the kit whether it should be as a methamphetamine or not. If the
Oh.
CFSL, without the CFSL report,
You are not an expert,
How-
Lordship.
my lord, without the CFSL report, how
Not
can
at
I,
this stage.
my lord, may kindly, my lord, I'm just laying this one judgment. My lord, may kindly consider it, my lord.
Let me see.
I'm not fighting. Huh? Lord, this is Lord, I just the same facts, my lord. It is also in commercial quantity, my lord. My lord, may kindly come to page number 4 of the judgment, my lord.
Here it was parity.
Pardon, my lord?
It was parity with the other two accused who were on.
Yes, yes, my lord, but the instance, my lord, the exception with regard to 37 has been said, my lord, in page number 4, my lord.
Yes, page number 4.
My lord, may I read, my lord, the third paragraph?
After her learned counsels, right?
Yes, my lord. As per the Caesar memo, as per the case made out by the prosecutor, commercial contempt on narcotics have been seized from the petitioner. The petitioner arrested on 16/9/2024. Inventories were made by the London magistrate on 17/9/2024. After the inventories, instead of sending the matter directly to CFSF, the investigation officer has taken the matter.
Facts are different.
Not the same facts, my lord, because they have not sent it directly to the CFSL. Not in the charge sheet, it has not been mentioned. A report directly administered, copy of investigation sent to the directly to the investigator. It is also found the petitioner arrested on so-and-so custody memo, but in the custody memo, arrest was not informed to the petitioner. Concerning above finds that the petitioner made out a case for section 37. Accordingly, the petitioner will be bail bond of 20,000. Lord, this is a fact, my lord.
I will not comment on this order, but then
My lord, I'm
not at this stage.
Not my respectful submission, my lord. At least the ladies may be released on bail.
No,
my
no.
lord.
Separate orders, but the same order would be there in both the cases. Heard learned counsels for the parties. Paragraph, learned counsel for the petitioner submits that the petitioner is in custody since 26 January.
Yes, my lord.
26 January 2025. Charge sheet has been submitted. The CFSL report has not been submitted as yet. It cannot be said that the alleged substance recovered from the house of the petitioner is narcotic substance. The petitioner prays for bail. Paragraph, learned counsel for the state opposes the prayer and submits that the recovered material has been sent for CFSL examination to Kolkata, but report is yet to be received. Paragraph. I have considered the material on record. Alleged narcotic substance above commercial quantity has been recovered from the petitioner. Stop in view of the restriction laid down under section 37 of the NDPS Act, therefore bill is rejected at this stage.
Obliged.
In view of the statutory restriction laid down under CRM such and such is disposed of. Or is it certified website? Both are disposed.
Same.
Separate orders, same. Next.
Item number 2, CRF 33 of 55.
Wait, please, my lords. My lords, this is a 528 BNSS, which is 482 quash petition. The FIR is dated 13/7/2025. The offences.
Lordship, today morning I have received two separate cases arising out of same FIR, Lord, so I have to go through the submission because today I have received.
My lords, I have few interim reliefs that I am seeking. So if I may be just permitted to make those.
Receive the copy today itself, so it's come back on Friday.
My lords, my only contention and my only request to this honorable court is, my lords, the accused are under an illegal detention for more than 72 hours. And my lords, that may be recorded
Why do you say illegal detention?
because they have, we ourselves have also said that they are willing to surrender. The police is not arresting them. The police is trying to ask them and ask indirectly to us for hefty sums of bribes.
They are in custody, no?
No, they are in illegal detention. They are not in custody.
Only FIR have been registered initially. Just new cases FIR have been registered against 3 persons regarding some cheat fund or other things. I couldn't go through this.
Cryptocurrency
Yeah.
scam. It's a cryptocurrency scam.
Cryptocurrency scam.
My lords,
Investigation is going on.
Seek to surrender.
we have already, my lords, we came and we surrendered. No 41A notices were issued. The entire family was being harassed for 1.5 weeks. Then finally, we went and we surrendered. Now, initially, we were told to come from morning till evening. We cooperated with the investigation. For the last 72 hours, they have not left the concerned accused in this matter. That is Mr. Wasim.
Lordship, that is different. It is for quashing of entire FIR. I found from the petition.
That's your
Yes. But for quashing of affair, that is irrelevant, surrendering or detaining.
My lords, in a 482, the Honorable High Court has inherent powers. And this is the current present position that I'm trying to
Powers
bring about.
within the prayers of the application.
Indeed, my lords, but I'm bringing to this Honorable Court the current position of how the concerned respondent police is behaving.
You've served the state. Have you served the third opposite party?
Not yet, my lords, because this was because
you
only upon the notice
You
issued by.
partially serve, isn't it? You've served the state, you say.
Yes,
You need to serve the private opposite party also.
I would take the
Please
no.
serve and come back on Friday,
Is it
day after.
is it
Can you
possible?
serve by day after?
I
Or you can come back on Saturday. Saturday is a working day for us. You can come back on Saturday also.
I'm an outstation counsel. I'll try my level best to serve the council. Yeah. But the primary prayers that I'm asking for in terms of quashing of this FIR on questions
That
at law.
would be done if you would not have served the state also. You've served half the parties.
But I
you've
was
not
given to
served.
understand by the procedures that I without serving the state, I cannot be present before you, my lords. Which is why I had to serve the
I
state.
don't know what's the procedure here at in the islands, but at the principal bench, criminal motions at the outset, they are moved without service. If you need an interim order.
Because
When I think
few other high courts also follow the same practice that I'm supposed to serve the state public prosecutor before appeal.
Other high courts.
Like even, for example, in
I'm
Kannada.
looking for the Calcutta
Yeah,
High Court, that is principal bench.
I understand, my lord. So even in Karnataka, for instance, where I come from, I'm supposed to.
An application even without service if there's an urgency. And after that, there's a direction. If an interim order is required, it is granted. If not, a direction is given for service.
Right.
But here, since you've served half the respondents, you need to serve all of them and come back.
As my
If you
lords may
can come
direct,
Friday?
but
Because by tomorrow, I don't think it will be possible. Tomorrow is Thursday.
I would.
When can you come? After service.
The respondent number 3 to serve them, it becomes difficult now because of
Why?
the reason. We are saying, my lords, to consider the interim prayer only. We're not asking for the main relief without the respondent number 3. It becomes difficult, my lords, to give the final relief without serving the respondent number 3. Now, my lords, as the police, they are here.
Let it appear on Friday because the state is also not ready today.
Please, my lords, let them get
Let us see. Please try to serve. Please try to serve. See if we
I would make my efforts
see
to
if
serve.
we can, right.
If not, my lords, my
let's see.
request is I may
We'll
be
take your-
heard on Friday.
I'll take a call on that.
That's a practice happens in Supreme Court also because the state is there, the standing council.
I'm not aware of the Supreme Court practice. I'm aware of the Calcutta High Court
I'm
practice.
requesting, my lords, but
It's just a humble request.
Go by the Calcutta High Court's practice.
It's just a
right?
humble request, my lords.
if there is so urgency, I'm just hearing the truth. That's
Yes, I understand. In that case, you shouldn't have served the state also. I could have considered it at the initial stage. It's a new motion.
I mean,
The practice here is you need to serve all the matters, even criminal motions. The principal practice is not that at all. Anyway, please try and serve by Friday. Let's see. Learned Counsel for the State seeks accommodation. Let the matter appear on the same hearing on 1st August.
Obliged.
much obliged.
Friday is 1st August. Next.
Item number 325.
It's coming for the first time. But what has happened?
You've served.
It's coming for the, unless this court directs civil division lawsuit, because I've prayed for some interim protection.
Great.
So what has happened?
This is the procedure in civil as well as criminal divisions.
Exactly.
I do not know.
Absolutely.
Anyway,
Lordship, the plaintiff filed a suit seeking declaration to get the suit land regularization in terms of the scheme, which is in vogue in this island. The defendant contested the suit, full dress trial was done. Ultimately, decree was granted in favor of plaintiff. Lordship, execution case was filed. The defendants received notice of execution case after 2 years. They have filed first regular appeal before the district judge. Since it's barred by limitation, they took out an application under Section 5 of Limitation Act. The date was fixed. My client appeared.
he sought for time. It was accorded by the first appellate court. On the second date, the other side took time. The appellants before the appellate court took time. The third date was fixed for filing written objection. On that day, because my client is more than 80 years and he hails from Havelock Island, he was bedridden, he informed the council to seek for a short date so that he can file the written objection so far as Section 5 is concerned. The first appellate court at the first instance rejected the adjournment application. Later on, in a mechanical way, allowed Section 5. Now, those lines of judgments, I'm unaware of. Liberal constructions to be made so Section 5. But after the Isha Bhattacharya judgments of Supreme Court, there are certain guidelines being taken. Now, here the delay is more than 2 years. It has not been explained why the appeal could be taken up after this period. The first ground is.
You are challenging that order?
Yes, my lord. Lord would find that immediately before Wakalatnama, the order, two orders, order number 4 and order number 5. I have annexed the entire order sheet of the first appellate court. Well, it's not that the suit was an ex parte one, it's a contested one.
Some reason has been recorded by the
So
district.
I can show my lords to the
The
very
first paragraph.
Section 5 application.
Why don't you fight it out on merits?
Not, I could have understand lordship, but the thing is, the facts is something else. No, delay has
Because
not been.
you have got a decree for eviction, right?
Absolutely, lordship, it's a contested decree.
Yes, so you
Lordship, the
need to fight
explanation
it
has been
on
not,
merits.
explanation has not been offered. I could have understand after the Isha Bhattacharya judgment, lordship, it clearly delineates.
We are
Lord,
all
not kindly
aware of
knows,
all
Lord
that.
knows there's not.
We are all aware of all that,
Lord.
but still I say, why don't you fight out the appeal on merits?
Not what I propose now. Lord, let the order be set
Because
aside, lordship, so far as
Your
section.
decree is getting delayed, right?
Lordship, I'm not
At
sure.
the end of the day, you are suffering.
No, I'm saying the order impugned and an ex parte order. Lordship, the first appellate court ought to have given an opportunity to my client, my lord, to contest Section 5 application. Well, kindly see how many dates were fixed the day from the appeal was belated.
You're
Appeal
asking for a
was
stay of this order?
operation of this order. Lordship. I'm seeking for stay of operation of this order. Lordship. Now, kindly see the first order may kindly
I'll
be.
stay this order, please serve and.
I'm grateful. I'm grateful. I'm grateful.
The petitioner has essayed the order passed by the learned district judge Andaman and Nicobar Islands on 27 June 2025 in title appeal 13 of 2024, allowing the prayer of the respondent under the private respondent under Section 5 of the Limitation Act. Paragraph, learned counsel for the petitioner submits that the petitioner sought adjournment on the day the application was fixed for hearing. The adjournment was refused and the application allowed ex parte, though no reason was assigned by the respondent justifying the delay of about 2 years in preferring the appeal. Paragraph. I have considered the submission made on behalf of the petitioner as well as the order impugned. The order impugned is an ex parte order upon turning down the prayer for adjournment made by the petitioner on the relevant date. It prima facie appears from the order impugned that the delay in referring the appeal by the private respondent has not been considered by the learned judge. Paragraph, in view of the above, comma, this court is inclined to hold that the petitioner has been able to make out an arguable case. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite party, upon the respondents, and file affidavit of service on the adjourned date. Paragraph, the order impugned dated 27th June 2025 be stayed till 31st August 2025 or until further orders, comma, whichever is earlier. Paragraph, the matter be placed before the next available
I'm
circumstance.
grateful.
Next,
I'm extremely obliged.
Item number 4, WP 330 of 2025.
Lord, as item number 4, I've been served with the copy. Lord, D has only made the Pradhan as a party. Lord, he is an elected body. And the Gram Panchayat has to be made as a party because this is statutory. I could represent,
yes. Gram Panchayat represented by the Pradhan.
but here, my lord,
That's technical. Nature.
Pradhan has been Gram.
Panchayat.
Yes,
Work order
yes,
issued by the Pradhan of Gram Panchayat.
yes.
I have made that party.
Cannot
see-
be in his personal capacity, right?
Lord, that is a
The
difficulty.
Work allotted by the Pradhan of Gram Panchayat. And I have completed the construction work.
And payment is not being made.
Yes,
That is your.
Yes. Thereafter, I have served a legal notice also. But they, in spite of taking the legal notice, they have not issued any reply yet. I have completed my work within 1 year. That is in the year of 2022, and now it is 2025.
What you are submitting is technical.
Not technical, because I cannot appear the Pradhan, my lord, because I am representing the Gram Panchayat secretary can.
To make necessary corrections in your
Yes.
cost title, let it be the Gram
Because-
Panchayat represented by the Pradhan. Please change
not-
the, that is
No,
what you
no,
are
your
saying.
lord, I signed this.
It is mentioned here.
No, Pradhan
First
means,
letter it is mentioned. The Pradhan Gram Panchayat.
Pradhan Gram Panchayat means Pradhan is the.
Of that
is in his
Gram
personal
Panchayat.
capacity. It should
so
be the.
it
Gram
should be, he
Panchayat.
has to appear either in person, no? Because being a state administration, we cannot represent him.
And that should be the ideal term.
Or my lord, the Panchayat secretary to be made as a party, so that we can appear the Panchayat
The work
secretary.
allotted by the Gram Panchayat, your lordship. Kindly see the annexure.
It is
Annexure.
private
Annex-
body.
Page 13, your lordship. Page 10 is the work order, and
Work
13
order
is
is issued by
issued by the
Pradhan.
Gram Panchayat.
By the Pradhan, right?
Yes, Pradhan. So I have made that.
You can represent the Gram Panchayat.
No, Panchayat secretary, we can represent, my lord. Because that's not issue.
Panchayat secretary is nowhere to
Who's the-
seen.
Lord, Gram
There is no-
Pradhan, I
It is
don't.
issued by the Pradhan.
But I've been, either it should be, he is interested to be engaged, or he can engage somebody, it's an individual capacity, he is, my lord. Because as my lord told us to take instruction, I gone to
The
the papers.
Pradhan is in his official capacity,
Yes.
right? So let it be Gram Panchayat represented by the Pradhan. Because the Pradhan has signed the work order. Why would the
Pradhan
secretary?
has signed the work, because my lord, he is to be, he is an elected body, that so far as, that's why.
Say, Gram Panchayat represented by the Pradhan.
Let me, my lord,
So
take whether I can represent the Pradhan if he gives an instructions.
Cannot, there be an expertise on. Please take
Well,
instructions and come back.
Yes, yes, ma'am. Let him not today, my lord, I take instructions.
Very well, come back to.
Yes, sir.
I'll allow him to do the necessary.
Yes, yes,
corrections.
yes, my lord.
Please do the corrections in the cost title.
Yes, sir.
Make it as Gram Panchayat represented by the Pradhan. Right?
I will correct.
On prayer of the petitioner, liberty is granted to correct the cause title of the application. Paragraph, learned counsel for the respondent seeks accommodation. The matter is adjourned for the day. Please
Yes,
come back.
yes, yes.
Right.
And please come back with the necessary instructions why the payment has not been done.
Yes, yes.
Next.
Item number 5, WPA 332 of 2025.
Maple, sir. Maple. Lord, I'm for the petitioner. Lord, I filed the affidavit service, my lord. It has been duly served to all the parties.
Mr. Shivram,
He was there.
where is he?
My email is appearing in the subordinate court number 2.
It's not a subordinate court, madam.
Not facts are very clear, my lord, because as work order was issued to
Let me pass it over for some.
Yes, yes, yes.
Passed over.
Number 6. WPS 335 of 2025. My lord, in this matter, I am appealing for the writ petition. My lord, this writ petition is pertaining to the legal construction made by the respondent number 3. So the official respondents have already passed the demolition order, but they are not implementing the same.
Who is appearing for Mr.
Lord,
Mr. Rakesh Kumar is
one,
here,
two, we are appearing for the one.
I am for the private respondent, Your Lordship. Let the official respondent say what they want to, then I will make my submission.
Yes, ma'am. The order is at P2, my lord. Annexure P2, page number 30.
1 and 2.
Yes, the official respondents.
Lord, we have issued the demolition order, and in terms of the regulation one, it has to be sent to the chairman for approval for executing the demolition order. In the meantime, Lord, the other
This
side
is
is.
the 2019 order.
Yes, yes, my lord. In the meantime, they produced that there is a civil suit and stay order was granted by the court. So based on that, we have.
So with regard to this.
With
this
regard
issue,
to, they said there was a stay, and with regard to that aspect, a notice was issued to them to give the stay order, whether the demolition order has been stayed. And after perusal of the stay order, my lord, it has been perused that no, this stay was not pertaining to the demolition order. And as such, my lord, it is again forwarded to the chairman for approval. If once the approval has been granted by chairman, we will implement the order of demolition.
approval is still awaiting.
Yes, ma'am.
Your Lordship, now may I
My
submit, Your
lord,
Lordship?
just
Your Lordship,
one more
and
submission, my lord.
Let him come, let him.
complete. Yes, ma'am. My lord, earlier also pertaining to the same proper writ petition was referred during the pendency of the writ petition, the official respondent
In the same matter.
in the same matter, but the private respondents would be different. Petitioner is the same. During the pendency of the same, they have within 2 days, they have obtained the permission from the chairperson and submitted before this honorable court that we had already got the approval and everything, so the writ petition can be disposed of. Implementation of 2019 order.
So this approval is waiting.
Yes,
now.
my lord, for approval they are. And at that writ petition, within 2 days, the authorities have brought the approval also, so that the writ petition was this. Yes.
Your Lordship, I am
Yes.
not aware of that decision. But here in
This is
case,
another case.
here in this case, what happened, Your Lordship, 2019, when the order was passed, the private respondents hearing believed that the interim order in the civil suit has already been passed. So they have informed, as said by the other side, they have informed the authorities that this is the interim order which has been passed, and you are not supposed to do anything because status quo order has been passed. Now the authorities also kept quiet. They did not do anything. Petitioners also was waiting that after the disposal of the civil suit only, the authorities may take action. We will also take action against the authorities if at all it is required. But then writ application has been filed. Immediately after filing of the writ application, those people, they came to me. I said that order has been passed in 2019, and possibly even if the interim order is there of the civil code, that is not going to help you because municipal council is not a party to the case. Then what is the actual thing? Then they said that before passing of this particular order of 2019, no notice, nothing has been issued to them. No hearing.
Have you challenged this order? No.
Yes. Thereafter, immediately we preferred an appeal. I have the copy of the appeal. We have preferred an appeal along with the application for condonation of delay before the deputy commissioner. This is the copy. So I
Have
can
you
find,
received notice of the appeal?
No, my lord.
Yeah,
take,
I also not have any instructions.
When did you file the appeal?
just recently, Your Lordship, because after filing of this writ application only we came to know. Yesterday only it has been filed.
This was filed on 17th.
29th, Your Lordship, yesterday only.
The writ was filed on
Yes, yes.
17th.
We received the copy very late.
When
We
did
received the
you-
copy, I think 2-3 days before.
When was it served?
Affidavit of service is on that.
Yes, when was it served?
24th of July.
Yes, Your Lord, that's what, Your Lordship. Within 3 days, I prepared the appeal and we have filed it. And exactly the same thing what I am submitting, Your Lordship, it's written in the condemnation application also. That they believe that the interim order is there of the civil court. So no action will be taken. And for last 7 years, 6 years, no action was taken also. And we have taken the ground that before passing of the impugned order, no opportunity of hearing has been given to us. No notice has been given to us. No hearing in fact took place. That ground we have taken in the appeal.
This is order dated order number 6949. You have assailed 6951 and
There are three cases.
7997.
There are 3 cases.
No, no, in this particular case?
Just a minute. No, this one. There are 3 cases, Your Lordship. So I have given the other 2 one.
Here also it is not, this is 6950 and 6998, not this order. Here the order number is 6949.
6949.
The order impugned is 6949.
Just.
In the cause title, you say 6949, but in the prayer portion, you have not said so.
Just 1 minute. I think there is a typing mistake, Your Lordship. I'll just clarify this. Just a minute. I'll just be one by one.
We are on 6949.
WPA, Your Lordship, WPA.
335 of 20.
Yes, sir.
By month. Abdul month. Efficiency.
You have allowed the respondent to file an appeal. 2019, 2025.
No,
You have been
prior
sitting
to
tight.
that, prior to that, we have continuously made the application before the authority, but authorities were asking for time. So
Your Lordship, I think in the prayer portion, it is correctly mentioned.
In the cause title, it's stated 6949. Prayer portion doesn't have this number.
Your Lordship, finally, Your Lordship. Thank you, Your Lordship. I'll just look into it and I'll get that. Your Lordship, this is a typing mistake, Your Lordship. Order number is not written. Date is written, but main order is changed. 799.
Since it is, yes.
my lord, further that,
Just a
one,
minute.
yes,
Your Lordship, kindly 7996 is there. 7996 is the.
This
main-
is 6949, this
Your
matter.
6949 is provisional order. Final order is 7996. In the same writ application, Your Lordship, kindly. Same writ application.
7996, yes.
This is the main order. 6949 is the provisional order.
Yes.
To be mentioned.
yes, ma'am. My lord, earlier one of the private respondent had preferred a writ petition before this honorable court on the same ground. When this honorable court had decided, they had intimated the honorable high court that they had preferred the appeal.
Even.
Yes, yes.
Division bench.
Yes, ma'am.
I will also bring it. When the division bench is held, there is appeal is pending. there is
Order
a-
of
yes,
devolution
ma'am.
is an appealable one, so they have preferred an appeal.
Yes, my lord, similar matter.
This is a yes, I'm reading
Yes,
from
my lord,
your
the
judgment.
direction, my lord, of the appellate authority to dispose of the same, only that. Yes, yes, only that I am
Give
asking.
the direct.
For that only I
Yes.
am asking.
I heard learned counsels for the parties. The petitioner seeks implementation of the order being number 7996, right?
Yes.
7996 dated 29th November 2019, issued by the Secretary, Municipal Council by the said authority. Paragraph. Learned Counsel for the private respondent submits that upon receipt of notice of the present writ application, an appeal has been preferred before the concerned authority assailing the order passed by the Secretary Municipal Council, along with an application under Section 5 of the Limitation Act, seeking condonation of delay in preferring the appeal. Paragraph. The order was passed on 15th November 2019, whereas the appeal has been preferred on yesterday, right?
Yes.
29th July 2019.
2025.
29 July 2025. Paragraph, be that as it may, since the order has been assailed by the private respondent in an appeal, the appellate authority is directed to consider and dispose of the appeal as expeditiously as possible, upon granting reasonable opportunity of hearing to both the parties, in accordance with law, keeping in mind the time lapse between passing of the order and preferring the appeal. Paragraph, since nothing further remains to be adjudicated in the present application, the writ application is disposed of.
My lord, the appellate authority time bound, my lord, because on earlier occasion.
I have stated as expeditiously as possible, no time, because Section 5 has to be allowed. That please add where I've stated the time as expeditiously. If the appeal is admitted, to dispose of the same. May not be admitted at all.
Okay.
Next.
Item number 7, WP 306
These are all same issues.
Same.
Madam. Order
Same
numbers would be
property.
different.
Please give the order
Yes,
numbers.
I will give it.
Yes. How many are there?
Three.
6,
Three.
7 and 8, madam.
6, 7 and 8.
Eight.
Great. Order numbers will be different,
Yes.
number and date. And please give a list of the order numbers.
Yes, my lord, I will provide.
Item number 9, WP 345 of 925.
Let's try for the petition.
Item 9.
Yes.
Sorry.
Respondents?
Lord, it has been, I've got the copies just now, Lord. That is the day after tomorrow I take
The
inside.
problem is that the execution order has been passed on 24.
In this matter?
27th, 22nd July.
In this matter?
Yes, I am praying for the stay of this particular order. And 15 days, your lordship, only is time given by the joint commissioner to deposit the amount.
Where is the interim order? I do not find an interim order here in this matter. Yes? This is appearing for the second time today.
No, Lord, she's saying that an authority has passed an order. She
We are
wants.
praying for an
for
interim
interim.
order.
Page number 24, I have paid for an interim order. The include order is your lordship at page number 157. 1 day time, your lordship, I have no objection. But
Day after tomorrow, I'm seeking.
Tomorrow, your lordship, it may be taken up because 15 days will expire, then I will be in difficulty.
But I'm praying it to be on Friday because I take
No,
instructions.
I will see 22nd July is the order. If it is fixed on Friday, your lordship, and
22nd, 15
I think
days is
15
not.
days will expire.
Ah.
The order is at page?
157.
Fifteen days from the date of service of the order. When did you receive the order?
I have to. So immediately thereafter, your lordship. I think on.
So this is a 6th May order, right?
No, 22nd July, your lordship. Order is 22nd July. Page number 157.
Yes, 22nd July and 15 days takes us to next Tuesday. So come back on Friday. Yes, next Tuesday. is- He's asking for Friday.
Till Friday.
Let us give him a date.
But I just now I got it, so I'm not.
Learned counsel for the respondents seeks accommodation. Let the matter appear under the same heading on. Will you come back on Saturday? 1st August. I need to keep some matters on Saturday. It's a working day. Hmm. Not in a single bench.
Your lordship, let it be on Saturday. Let it be on Saturday.
We'll get time to
Yes,
discuss.
let it be.
Yes,
Yes.
Saturday, 2nd. Thank you.
Then WPS 348 of 25.
Yes,
Hearing for the petitioner.
yes.
I have approached the Honorable Court seeking issuance of transfer certificate in favor of the minor.
Have you served?
The affidavit of service has been filed here also, but the track report has not been next yet.
Come back with the track report.
No.
You need to serve both the respondents. Can you come back tomorrow?
Let this be fixed on Saturday.
Saturday? Well. Since a service upon the respondents is not complete, comma, let the matter stand over till 2nd August 2020.
Right.
Item number 11, WPS 350 of 25. 11.
No one? None appears for the parties? Yes, Monday. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 4th August. Next.
Number 1. WPS 694.
Your lordship, I am for the petition. Your lordship.
They have filed, served a copy of supplementary affidavit. No, opposition we have filed them. We have filed.
Receive the copy of.
It has been filed. Copy दिया नहीं. Register में देखो.
Filing order भी नहीं.
File नहीं.
December, the order was passed, your lordship, for filing the affidavit in opposition.
Yes.
And I think, your lordship, they are saying they have filed it. But even if they have filed
Yes,
it,
affidavit in opposition is on
but they
record.
have not given me any copy of that.
I make a copy. and-
That is the reason I think in the subsequent orders also that is not recorded. That affidavit in
There is
opposition.
no
And
subsequent order.
Thereafter, it is not listed, I suppose.
Any list was mentioned.
No,
I don't find it was listed.
but thereafter it is not listed.
Anyway, please give her a
I
copy.
just give.
Let it be on Monday, your lordship, for hearing. In the meantime, I'll file my reply and give an advance.
You can
copy.
file your reply by
Yes,
Monday.
yes.
And this is your supplementary affidavit, you're filing it today?
Already filed. your
It's
lordship.
already-
Also-
Today I have received copy.
Checking copy to the-
Yes.
Today I received supplementary copy. I just go through it.
Supplementary affidavit filed by the petitioners is taken on record. Paragraph on prayer of the
Copy
supplementary affidavit filed by the petitioners and affidavit in opposition filed by the respondents are taken on record. Paragraph on prayer of the petitioners, liberty is granted to use a reply to the affidavit. Paragraph, let the matter appear under the same heading on. This will be under the heading hearing. Hearing on Monday, 4th August.
Apply.
Next.
Item number 30.
Lord, this matter, Mr. Satadu Chakravarti will appear because Lord, I cannot appear in this matter. Earlier, I was made an appearance.
Yes.
So judges will not today, but he will come in virtual mode tomorrow. Judges will not today.
On prayer of the respondents, the matter is adjourned for the day. Next.
Item number 14. WPA 290 of 2024, 25.
For the respondent.
Ask me to serve the copy again to the private respondent. So I served the copy of option, but they didn't get the track details.
You need to have the track report, right?
Fix for Monday. Already ST has been granted by some group for 4 weeks. What about these government laws? And so to bring the revenue case also.
Yes.
On that day.
The revenue case.
I have got it.
You have it?
Yes, I have.
So please serve and come back Monday. Since service upon the private respondent is not complete, comma, let the matter stand over till 4th August.
Obliged, my lord.
Next.
Item number 15, WCA 342 of 125.
Lordship, I am respondent, Lordship. Just today morning, he has handed over the brief. Let me take instruction, let it tomorrow, day after tomorrow.
Day after.
Lordship. It is for grant of electricity connection.
Day after tomorrow.
Obliged.
On prayer of the respondents, comma, let the matter appear under the same heading on 1st August. Day after is 1st August.
Obliged.
Next.
Item number 16, here on 125.
Lordship, I am for the respondent number 1, the accused person. It is a state has prepared an appeal for enhancement of punishment. He was granted 3 years punishment. The paperwork has come, Lordship. I have filed my wakatama in the last circuit. I pray that the paperwork may be given to me, Lordship. Since I have not been a counsel in the trial court, I was applying for some time, Lordship, to go through the instant case, Lord.
Session and enhancement. These are the 2 points. Please make paperwork has to be handed over to me.
Yes, Lord. Registry may be directed.
Should be spare paperbooks.
Registry there.
Yes. It has to be prepared. It will not be so fast.
Yes, Lord.
Because at the tribunal, the respondent not.
Victim girls, sir. It was accused. You're appearing for the victim girl, right?
I'm appearing for the.
You don't have the paper book.
I have got the paper book.
That's okay.
I got the paper book.
We find that you also have a.
We both have.
So I find there's a spare paper book.
Paper, so it has to be handed over to you.
So let this be given to him.
Yes.
When will you come back?
Lordship, I'm praying for some time because I was not with the counsel in the trial court also. Can
Come up for, state has come for the enhancement. Now this enhancement will go up to 20 years if it is good. In that event, this matter has to be placed before the division bench. Above 7 years, it has to be
Yes,
placed before
yes,
the,
yes.
that has to be done. Now, order can be passed to that effect that it has to be placed before the division.
I think let that be done because let both the issues be decided by the division bench in that case.
Criminal appellate side moves.
Yes, yes.
Comes for enhancement.
Has to be, yes. The state seeks, before that, paper book is made over to learned counsel for the. Or let this submission be made before the division bench is. Oh, amicable transfer. Uh, Since the state has sought enhancement of punishment of the accused, for offense punishable under where is the conviction order?
7. It was done under section 7, 7 and 8.
Punishable under section 7
and
slash 8 of the Protection of Children from Sexual Offences Act, 2012, which the maximum punishment is POCSO, I think.
POCSO 3, 4. This year,
Maximum is 5 years. 7 or 8 by 5 years.
7 and 8 is.
5 years maximum.
But under section
It's
3 and
only
4.
3. This is not 3, and that's why I wanted to see the sections. 7, 8 cannot be 20.
It's 5 years, Lordship. Maximum 3 to 5 years.
Yes, so it will be here.
Yes, Lordship.
The conviction is under 7, 8.
Yes, Lordship.
Extend to 5 years and share.
So it will be before the single bench. Copy the, this is not required. Paper book is made over to learned counsel for the accused in court this day. When can you come back? Next circuit.
Praying, Lordship. Because yes, Lordship.
Huh?
Yes, Lordship. Next circuit.
He wants to come back in the next circuit.
Let it be placed before the honorable division bench, and thereafter we can.
Division bench is not required. Up
No,
to
no.
5 years.
Lordship, for enhancement, when I have come,
The maximum punishment is 5 years.
it is 3,
So,
5 years.
so how can enhancement be more than 5 years?
No, Lordship, I am seeking that a lesser punishment has been awarded when the case has been made out under section 3 and 4 of POCSO Act. It's a clear-cut case of 3 and 4, not on 7. 7th already court has given.
Yes.
So we have come for enhancement, which goes up in 3 to 4. Having a biological father conducted such a thing.
If the thinks that it will be under 3, 4, it will be sent to the single bench has to decide. Whether it is under 3, 4 or 7, 8.
The entire hearing is to be taken place. Thereafter, court will decide. Because court has to come into a
Because the
separation.
entire hearing has
For
to take
criminal-
place before any of the benches, whether it's the division bench or the single bench. If the division bench hears the entire matter and finds that it will be 7, 8 and not 3, 4, it has to again to be sent back. So it's when it is already before this court, let the single bench deal with the matter. If the single bench finds prima facie that it can be under 3, 4, it will be sent.
In that event, let it be taken up tomorrow. I'll bring the criminal appellate
He
rules.
wants some time.
Criminal appellate rules. We'll just see whether it is
Till
it will be
7, conviction till 7 years, single bench. That is clear.
Yeah.
But here you ask for enhancement. If enhancement is required only, then it will be sent to the division bench.
I'm on the point that enhancement hearing will be done by which bench? Single bench or by division bench?
Single
Yeah, I'll just come tomorrow. I'll bring the criminal rules and order. Appellate side rules. Sorry.
We have appellate said rules and orders. Huh? As far as I can recollect, the rules only say 7 years and above. Yes. Only if it is above 7 years, then it will go to the revision bench, not at this stage. He's asking for next circuit, let it be. Paperwork made over? Yes? In court this day. In court this day. Paragraph on prayer of learned counsel. The matter be placed before the next available circuit bench. Next.
Item number 17, 22 of 1995.
My lord, I am appearing for the petitioner, my lord. This is seeking extension of mandate, my lord, of the learned arbitrator, Mr. Ajay Krishna Chatterjee, senior advocate, my lord, who was appointed as arbitrator by this court, my lord. The respondent has sought time in the past also, my lord, to file reply. They appear to be opposing the application.
In this case, we are also filing a different application for substitute.
Have you filed an affidavit in opposition?
CP tried to file it. The deputy respondent is not in station B to affirm the petition. That is a
Next circuit.
My lord.
Will not be available next week.
My lord. My lord.
1 week.
okay.
The respondent seeks extension of further extension of time to use the affidavit in opposition as sought. Paragraph affidavit in opposition be filed within 1 week from date. Affidavit in reply, comma, if any, comma, be filed within a week thereafter.
My lord.
Paragraph, the matter be placed before the next available circuit. Next.
Item number 18.
My lord, I am appearing for the respondent, my lord. This is a matter of contempt, my lord. Contempt.
Contempt of whose order?
Oh, his lordship is not available, my lord. Order of my lord, just
This is
Yes. Nizamuddin's order.
Then I can deal with it.
Although, my lord, what has happened is they are seeking contempt of two orders. One is 12th August 24 order passed in contempt proceedings by Justice Shugato Majumdar. So, my lord, perhaps this should be placed before his lordship, because now the contempt that is being alleged is of an order of 12th August 24. If my lord sees that order, which is passed in these proceedings,
Give you a minute, please. February 26th order by Justice Nizamuddin.
yes, but now the allegation is, my lord, that we have subsequent to that, my lord, in these proceedings, my lord, this matter is CPAN 37 of 24, a CAN application, my lord, was filed. And my lord, on 12th August 24, my lord, if my lord sees that order of 12th August 24, possibly the petitioner won't dispute what I'm saying. 12th August 24 order, my lord.
Yes.
This records, my lord, CPAN number such and such, praying for stay of order dated 9th August 24, issued by Tehsildar Port Blair and restraining Tehsildar or revenue officer not to give effect to the order. Then my lord will see, in order to avoid any future complication or multiplicity, administration shall not give effect to order of Tehsildar Port Blair dated 9th August 24 for limited period of 20 days. Mr. Khan shall serve copy of the application. Now this order was passed in the contempt, my lord. But of course, they are alleging violation of an order passed by His Lordship Justice Nizamuddin. So it can be taken up before Lordship, perhaps, my lord.
Is this order complied with?
We are saying we have filed affidavit of compliance saying it has been complied with. They are saying it is not. They are dissatisfied with that. We have filed 2 affidavits of compliance, but they are saying that according to them, there is no compliance.
Yes, you are appearing for the applicant? Yes,
Order first page 50.
yes.
What is the only? Which is the writ petition, learned advocate for the respective parties are present, exception to the report of the Tahsildar filed by the petitioner be kept to record, or as for other respondent or the petitioner is satisfied with the action taken by them. Learned advocate for the petitioner has grievance only against the
So
respondent.
what are the directions in serial number 1 and 4?
Yes. That is.
Those were directed to be complied with.
Yes.
right?
Yes, my lord.
Where is the serial number 1 and 4?
This is set out in our affidavit of compliance. If my lord sees affidavit of compliance filed by Mr. Vinayak Chamadia, there are 2 affidavits. One is filed by Mr. Vinayak Chamadia and the other is filed by Mr. Thomas Varghese.
That
If
order
my-
is 32. If the order of the deputy commission which was not implemented, then that petition was filed. 32 start from the conditions. which is
Yes, 1 and 4. Yes.
34, 33, 33. No fresh construction shall be undertaken on survey number 146 in village Wimbledon. Further, the construction of boundary wall, any new addition in survey number 16 should be ascertained and removed by the taken over. The Tahsildar program and the station officer PS concerned shall take appropriate steps to ensure the same. Next, construction of color. This was complied with.
1 and 4. 1 and 4 are the.
Moreover, the sub-regional officer South Andaman, Assistant Commissioner directed to initiate appropriate action as per the relevant section of law on the irregularities found in the various reports produced in the said case. A reader shall make the said reports available to the SDO and further investigation. These 2 were not complied with. Honorable Court directed to comply with these 2.
Have you seen the affidavits of compliance?
What the Tahsildar did.
Affidavit of compliance, yes.
This is affidavit of compliance. They are saying that they initiated proceeding against me in another survey number. Part 1.1 number 1 says 46, survey number 146. They initiated proceeding against me showing as encroacher of another portion of the land, another survey number. How this is a compliance by the Tahsildar?
আরেকটা affidavit of compliance হবে দুটো রিপ্লাই
My lord, may I place the affidavit of compliance since contempt proceedings, my lords, I have to answer, my lord.
Yes, yes.
Kindly see, my lord, the first affidavit, and my learned friend can respond to me in case he is disagreeing. Kindly see the first affidavit of compliance is filed by Mr. Vinayak Chamadia,
Yes.
son of Sri Sandeep Chamadia, holding post of subdivisional officer. Now, kindly see, my lord, paragraph 2, I say that in compliance of the above order, which is essentially the order of this honorable court directing the authorities to comply with that order passed by the deputy commissioner. The following steps are taken by alleged contemptor. A. No fresh construction has been undertaken over survey number 146 in village Bimlitan, or has any new addition of boundary wall being done over survey number 146 carried out and reported by Tahsildar. The construction of culvert is B is completed and ingress and egress of the petitioner other residents of the locality is open for movement without any hindrance and accessibility to their residence is available. C. The claim of the petitioner for ingress and egress through survey number 146 could not be accorded as the said property is recorded in favor of a private tenant. D. The incumbent official has been transferred to Ferrarganj Tehsil from Port Blair Tehsil. In addition, show cause notice has also been served to official concerned for explanation, and appropriate disciplinary action will be taken after due procedure. And E. The ingress and egress is available to the petitioner and others.
We are concerned with A and D only.
Yes, now my lord, kindly see, my lord, if this A and D, my lord, is read in conjointly with the direction, my lord. Kindly see the direction. The direction, my lord, which was passed in the order of the passed by the deputy commissioner.
Yes. Yes, I've seen that. Let us hear what the
No, so we are submitting, my lord, if there are any factual disputes, my lord, then that, my lord, is fresh cause of action, my lord, because according to us, my lord, in our humble submission, my lord, we have complied with the directions, my lord. Now, A and D, if my lord sees serial number 1 in the Deputy Commissioner's order, serial
Yes.
number 1 is no fresh construction shall be undertaken over survey number 146. Further construction, new additions would be ascertained. Now, this has been done. And 4 is subdivisional officer to initiate appropriate action on the irregularities found. So the subdivisional officer has in his affidavit, my lord, stated both things. He has said that he has no fresh, kindly see again serial number A. Serial number A says no fresh construction has been undertaken over survey number 146 or has any new addition of boundary wall been done. So
Yes.
according to us, we have complied with A. And D is the, my lord, incumbent official has been transferred. In addition, show cause notice has been served. So we have stated on affidavit, my lord, that these steps have been taken. So in this view of the matter, my lord, and if they are disputing what we have stated on affidavit, my lord, then, my lord, that is not, my lord, in my humble submission, if they want to lead evidence to say that what is being stated is incorrect, my lord, then, my lord, they have to institute appropriate proceedings, my lord.
Let us hear the.
My contention is that it was directed, ascertain and remove. Where is the removal of that?
If there is
Clause
no additional construction, there is no question of removal.
The removal is there.
There is, if any, it has to be ascertained and then removed. So they have ascertained that there is no further construction.
Construction already made has to be removed so that I can get the ingress and egress. It is not compliant. What is their complaint?
Please see one is no fresh construction shall be undertaken.
Yes,
So they say no fresh construction has been undertaken.
but all the construction which was obstructing, it was ordered to be removed.
Where is that stated?
It is to be removed. Kindly see their compliance. Whether it was done in compliance of this order. Order number 9 dated 2024. They passed this order that we are compliant.
Where is the non-compliance? Please show me.
This is the order of non-compliance. Kindly see. Where is the steps taken to this, considering the A and D? Nothing is there. What action taken against the person, whether suspended, who was suspended, what action taken? There is nothing disclosed in the affidavit.
Well, I find that this is substantially complied with.
Lordship, kindly come to.
If you are not happy with the compliance, that's a separate cause of
This order
action.
cannot be sustained because they, in compliance of the order of Justice Nizamuddin, they passed this order. Kindly see in the CAN application, order dated 9 August 2024. It is showing that they are complying with. By this order, they passed a eviction order against me in showing another survey number.
That is not subject matter of the contempt proceedings. If they are aggrieved by it, they have to challenge it in accordance with law. That was not subject matter of Justice Nizamuddin's order also.
It is very limited, but it is compliance. They pass this order, whether in the compliance on the name of this order, they can pass this order, which is showing that a compliance.
Well, this is substantially complied with.
This is not complied with at all.
I'll record your objection.
Lordship, kindly see, once again, kindly come to the order of the Deputy Commissioner.
1 and D, to be very specific.
1 and D.
Yes.
Page 32. No fresh construction shall be undertaking of survey number 146. Further construction of boundary walls of any or new addition.
Any new addition.
Ascertain and
Yes.
remove. Tahsildar, station officer, concerned shall take appropriate practice steps to ensure the same.
Yes.
Construction was already made.
If it has to be ascertained whether there was
Where is
any
the
earlier
assertion? Where is
construction.
the assertion? Where is
They
the-
have stated that there is no addition to
It is
any.
only on affidavit. Where is the report that no construction is made? That's
Sir,
why this court
I'm
directed
sorry.
them. That's
This
why
is substantial compliance.
this court
There is a
directed them
compliance
to
report
file an
also.
affidavit of compliance.
This is the affidavit of
It
compliance.
is only an affidavit enclosing the document. What report they obtained.
This is called
construction
affidavit
made.
of compliance and a report is annexed to the affidavit.
You know,
Annexure A.
This report is contrary to the order passed by this
I'll
court.
record your submission, sir.
Court is accepting this and left free this person. Clear contempt of the court. Both the Chamak as well as the Burgess.
Whatever you are saying, fresh cause of action, you need to go before the.
Perfection.
No. This is sufficient, substantial compliance.
This is not at all substantial compliance.
Heard direct counsels for the parties. Peruse the affidavits of compliance as well as exceptions used thereto. Paragraph learned counsel for the applicant slash petitioner submits that the order under contempt has not been complied with by the alleged contemners. Paragraph on careful perusal of the order under contempt vis-a-vis the affidavit of compliance used by the alleged contemners, this court is of the view that the order under contempt has been substantially complied with. Paragraph in view of the above, the complaint application is disposed of. There shall, however, be no orders to cause as is certified.
As far as the order passed on 9th August 2024.
That was an interim order passed in the CAN.
Not interim order, right? It's in CAN application.
I have seen that. That's an interim order, 20 days. It was,
No.
sir, I understand where the shoe pinches. You have to
Yeah,
take
this-
necessary steps.
No, this order cannot be remained because they are showing compliance this compliance they are showing.
Compliance of the order under contempt.
So this order cannot
That
be.
has been
under the
complied with, sir.
This
If
order
you are
cannot-
unhappy, you have to go before the appropriate forum.
Nothing-
I am
this order-
sorry.
In CAN application, order cannot be sustained because this is not the in compliance of the order. If your lordship accepting their affidavit in compliance, so this order cannot extend. This order ought to have been cancelled.
Yes, there is no further extension of the order at all. The order is not there anymore. It was for 20 days. Then the order
CAN application, this
20th,
order,
CAN at
in
20th.
CAN application, I challenge this.
20th, CAN at 20th. Order sheets.
9 August 2024 order must go. Lordship accepting their compliance, it is a discretion of this court. But this order, as they are saying in compliance of the order passed by the Honorable
9th
High
August
Court,
24.
it was misstated. And time to time it was extended.
It was 20 days. After that,
If sometime after.
is it still there?
This order, they should not give effect. Because your lordship saying that
They have to challenge that order, my lord. That is not subject matter of the proceedings, my lord. They have to challenge that order.
Is the stay can continuing till date? I do not find any such order.
It was continuing, but sometimes.
But now it is not there at all. The order is not there at all.
My CAN application is there to that. If they are saying that we comply with the order of the court, but this cannot be in compliance.
This
of
is
the
a, we must remember that this is a contempt application. The scope is extremely limited.
Your lordship,
It is
in
only
that-
with regard to compliance of the order under
that
contempt,
case,
nothing
I
more,
will be
nothing
given
less.
liberty to challenge that order in the CAN application.
That you can challenge that.
Yes.
I mean, the law gives you the liberty.
No, because my
It's
CAN
not-
application is pending here. So I have to take records of law.
What is the prayer in the can?
Can only for
To stay the order dated, so
Yes.
when this order has already been complied with, the can is infructuous.
No, this order has not been complied.
9th August order.
Complied.
Tehsildar,
The matter is
that is
pending.
the order under contempt. The 9th August order.
9th August order was not part of the content. They find it that we are complied with this. Along with the affidavit of compliance.
Give me,
filed by
give me a
Mr.
minute, please.
Papaparis.
The order under contempt is 21st September.
Yes. The 26th February 2024. 26th February.
21st
2024,
September 2023 is the order under
Order-
contempt.
That's it, Deputy Commissioner.
Yes, that is 21st
It was
September
direct-
2020.
It was directed to be complied with. by
Yes,
the-
that is the September order. Yes.
But they passed the order on 9th August. Showing that we have complied with the order passed in inspection number 120. Kindly come to
Where is the 9th August order issued by the Tehsildar?
CAN application window.
At page?
To the page 80.
This is subsequent to the earlier order.
9th August 2024, an order was passed by this court on 26 February 2024.
9th August is the Tehsildar's order.
9th August Tehsildar order means saying that as per the 21st September 2023.
You asked for a
complied.
stay of that order. Yes.
Your Lord.
That order is pursuant to the earlier order under contempt.
Yes.
Yes. So when that order goes, I mean, that is complied with, this doesn't remain.
Slightly make observation. That's I want.
No, because a part, his grievance, my lord, appears to be that the Tehsildar, while complying with the order, has done something which affects his rights independently. So in that case, he has to challenge that order, my lord, because that anyway was not the subject matter of the proceedings before the writ court.
Just a minute, Your Lord. Kindly see.
I'll add that you can challenge this order in accordance with
The Tehsildar files false affidavit before this court enclosing this order we
Before
have complied.
paragraph, before parting with the record, comma. This court records that in Can 1 of 2024, comma, the applicant petitioner prayed for stay of the order dated 9th August 2024 issued by the Tehsildar, comma, Port Blair. It appears that the said order was issued pursuant to the order dated 21st September 2023, which has already been complied with by the alleged contemners pursuant to the direction of this court. However, comma, the applicant petitioner shall be at liberty to assail the I do not know how you'll assail this order now. It has already been complied with the parent order.
So that's because, you know, another putting this was passed. Non 146 survey number.
However, comma, on prayer of the applicant petitioner, comma, liberty is granted to assail the liberty is granted to the applicant petitioner to take necessary steps in accordance with law in the event he is aggrieved by the order dated 9th August 2024.
My lord.
Can 1 of 2024 is disposed of accordingly.
My lord.
Next.
Number 19, WPA 289 of 2019.
But this matter is connected to a series of matters, which is currently pending for the tribunal.
This matter, my lord,
Now, this is the third
in
of.
this matter, my lord, I am appearing for the UGC, University Grant Commission.
Out
My
of
lord,
the.
copy has not been served in spite of
You're out of
repeated
matter.
direction.
Still dealing with the matter.
Is still dealing with the matter. I don't know why it is listed time and again, Manoj. The registry sends it up. Your lordship will see there's an order of my lord Justice Shengupta's, there's an order of my lord Justice Kaushik Chandra, there's an order of the circuit before that as well, I forget. On each occasion, the matter is sent out of the list. It was linked with another writ petition. That writ petition has been withdrawn and is disposed of. Now, this is tethered to life with the OA pending before the tribunal. And that matter is fixed for hearing in September. In the September circuit of the tribunal.
So this similar issue is pending, right? That is your.
It is a connected issue. A similar issue, in fact, an identical issue was there before both courts. This court initially adjourned the matter sine die and said you take it up before the tribunal. The tribunal told me, look, this issue is one which if we pass an order, it will impinge on the High Court's jurisdiction. So you first take it up at the High Court. Then we came back here. Then the High Court said, you do one thing, you withdraw this application, agitated
You've
there,
withdrawn one of them,
one of them.
Why did
This
you
is
do
the
this also?
No, because this one, my lord, the cause of action is still alive. Other one was with regard to quo warranto. So quo warranto was filed here. The CAT initially, your lordship is aware that the tribunal, as per its usual business, deals with service matters, but cannot exercise a writ of quo warranto. Because quo warranto does not deal with the service of the applicant, it deals with the service of someone else who is sought to be unseated. But on this occasion, the tribunal has held that they have jurisdiction because those persons' services are irretrievably connected with mine. Therefore, they said we will exercise jurisdiction. So then we withdrew the quo warranto from here. This writ petition is on a slightly different cause of action. This remains alive till that OA is disposed of. If I succeed there, this will become infructuous.
Yes.
But if I do not succeed there, then I have to come up against that order in WPCT and this will stand revived. So that is why the lordships had said the quo warranto adjourn sine die that I have withdrawn, and this one was directed to go out of list with liberty to mention.
My lord, in this matter, my lord, I am appearing for the University Grant Commission.
Yes.
University Grant Commission, I am appearing, but no copy has been served in spite of repeated direction. My lord.
I'll direct the matter to go out of list for the time being.
Yes, my lord, but direct him to serve copy of the
He is interested in the
writ
copy.
petition upon me, my lord.
Ask for the
Copy
copy.
of the writ petition. I have requested several times and direction has been given.
Send this
Copy
writ-
of the writ petition. Kindly soft copy may be given to us.
This is an
It has
old
been
matter.
sent to you. Do you have
Yes,
a
ma'am.
copy?
I am
I can receive the copy physically for you.
either physically or soft copy may be given, my lord.
Soft copy I can send just now.
Learned Counsel will send a soft
Soft
copy.
copy may be given.
Yes, yes. he's
Yes,
agreed.
my lord, I shall receive.
Share
Soft
the
copy.
details with one of my colleagues.
I am appearing for the UGC, my lord, University Grant Commission.
My lord, I am appearing for the administration.
Yes, so let the matter go out of list.
My lord, my lord. Yes, my lord.
Yes, my lord.
That is with everyone's consent, it has gone out of list. I don't know why it comes back because we have not mentioned it.
The observations made by this court earlier with regard to pendency of a similar issue before the Central Administrative Tribunal,
Yes, my lord. In
And the
that
ma-
matter, I am also appearing.
for the time being.
My lord, kindly direct, my lord, until unless my direction is being given, my lord, no copy shall be served. Kindly,
Serve a copy. He is very anxious about the book.
Understand the
that's
situation.
why, my lord.
Out of list. Next.
My lord.
Obliged to lord.
Item number 20, WK 923.
I pay for respondent authorities.
On prayer of the petitioner, the matter is adjourned for the day.
Item number 21.
For the respondent, my lord.
Yes.
Better.
Before I give the judgments, I just want to show one thing.
I'll ask something. Can you complete within 20 minutes? Or rather 15 minutes? There is a full court reference today at 3:30, so I need to be there.
20 minutes if it's not.
Not possible.
Judgments, channels.
Will you come back tomorrow?
My lord.
I'll take up the shorter matters. By consent of the parties, let the matter appear under the same heading. Tomorrow, that is the date, tomorrow's date. These are all hearing matters. Next, short matters. Let me call.
Item number 22. Here are 23 of 24.
In this half of this CBI state, my lord, my brother coverage is for the petitioner.
Yes.
Similarly, 4 matters were placed. in
Yes,
the court
yes.
number 2, it was released from that honorable court to this honorable.
4 matters are here before this court.
No, there were 8 matters, my lord. 4 was yesterday, court number 2, yesterday the submission was advanced and that has got to release and sent to this honorable court. Can it be tomorrow?
Please take a note of this. All the 8 matters will be together. By consent of the party, the matter is adjourned for the day. 22, 23, 24 and 25, right? Please give the numbers of the other 4 matters so that they can be. Yes, please do.
Item number 26, WPA Tribunal number 24. Yes, I am waiting for the private aspect from the 4 and 5. Saying for not wait.
You are the petitioner. Who is the petitioner? Where, sir? On prayer of the petitioner, the matter is adjourned for the day.
Item 27, WPA 360 contradictory, item number 28.
And very good response.
Same order. On prayer of the petitioner, the matter is adjourned for the day.
Item number 29, WPA 470 contradictory.
Notice direct response.
Petitioner?
This is the matter.
They should go before the Waqf board.
Oh, this is the work. Yesterday also it was not to, make your submission. I'll release this, let it go before, withdraw this, go before the appropriate forum.
That is the best.
Withdraw, go before the appropriate forum. Yesterday also it was not today, I remember. No.
From the writ petition itself, it will appear. But it's a disputed question. They say it's a work property, we say it's.
You have seen the application? You know that it is a Waqf property?
But we are not seeking for the, we are seeking the direction upon the CEO of the work tribunal to take an action. Until others action will take, taken.
An action for what?
To take the position of the work properties.
They say that it's a work property, we say it's not a work property.
So that has to be decided by the tribunal.
One day,
No,
but one day.
the petitioner seeks to. Make it like this. You tell your senior that the court has not allowed, right? On prayer of the. How many 1 days can be given? No. Where is your senior? Where is your senior? On prayer of the petitioner, liberty is granted to withdraw the application and take appropriate steps before the. Take necessary steps before the appropriate forum.
Blair.
Next.
My lord.
The writ petition is disposed of as withdrawn. 30.
30, my lord, yesterday, my lord, the matter was taken up. I think petitioner's advocate is not here, Miss Naga.
My lord, as
Yesterday, my lord, there was my lord, this is that matter, my lord, where we had to inform the status of leave encashment. What is how many days leave encashment has been granted. So, my lord, we have filed an affidavit today, my lord. I don't know if it has come before the court, my lord.
So, your lordship, let it be not today, tomorrow can be taken up and disposed of. It's an interest on retiral dues. So, I will be facing judgments and I will look into it, what is written there.
Tomorrow?
Yes,
My
tomorrow.
lord.
You are using the affidavit today?
My lord, as in terms of earlier that we have to enclose the details of the payment.
Yes.
We have given, I just given today by way of an
Are you
affidavit.
filing it today?
Already filed in the registry, my lord.
It's- Affidavit used by respondent numbers 1 and 2 is taken on record. Paragraph on prayer of the petitioner, the matter is adjourned for the day.
My lord.
Item number 31, Session 7 of 925.
Your lordship, in this case, some more time is required for the paper book,
Not prepared.
not prepared. Your lordship.
Next circuit.
Let it be on Monday, your lordship, I'll try. If possible, if it is, otherwise, your lordship, it will be go to next. Because we don't have many matters in the list.
No, we don't. I don't mind taking up matters. I mean,
No, if.
I would love to, but
Yes,
then
if it is
can
permit, if we are able to reach, your lordship, we'll do it.
let it be Tuesday.
Tuesday. Your Lordship.
We will be able to reach. I have completed the list.
Yes,
That
yes.
will not be a difficulty. Very
Sometimes
well.
one or two matters is taken up, it goes on long, your lordship, that's all.
Can't help, can't help. There are certain lengthy matters that
Yes.
also needs to be disposed of, right? On prayer of the petitioner, let the matter appear under the same heading on 5th of December, Tuesday.
Yeah.
But one password,
Please call him now.
one password matter.
Yes, one passover matter, yes.
So,
Number 5.
You are appearing?
no, I'm for the petitioner. They are for the.
I did not receive the copy or.
No, already served long
Yes.
back. I filed affidavit service also.
Yesterday,
Personally, it has
I
been served.
directed him to serve the copy.
Yeah. But I'm given it.
It will be
The issues
Come
very
up on
small,
Saturday, ma'am.
because I made my work. I submitted the bill. I made a representation.
Saturday.
Saturday.
You are coming on Saturday.
Yes, sir.
ETA meeting.
By consent of the parties, let the matter appear under the same heading on 2nd August.
Pleasure.
Let us do some work on
Yes,
Saturday.
yes.
Some matters.
My lord.
Ballot because we have to.
Pleasure.